एक महीना बाद सीरियल नंबर 7 at the request of Ms. Vani Kumari, the matter is adjourned and is directed to be posted on 30th in the supplementary post list. अदर साइड कौन है इस खबर का?
लास्ट टाइम भी अपीयर नहीं किए
थे लेकिन somebody has entered appearance. Mr. Niranjan Kumar has entered appearance. फाइल पढ़ के आए हैं.
अच्छा हमको
He has entered appearance. हम उनको खबर कर दीजिए. पूरा ही पढ़ के आए थे. चलिए कोई बात.
Some supplementary list for orders modified item 1, first appeal 264 of 2023.
4 weeks time for termination of delay, I will have to file one I. For the defect number 5 and 7, the record will be sent to the lower court.
Sorry?
For defect number 5 and 7, there are some differences in decree and judgment. Therefore, the record may be sent to the lower court.
फाइल देखते नहीं है. वहाँ से लोअर कोर्ट से होके वापस भी आ गया इलेक्शन.
तो एक लिमिटेशन क्या है 4 weeks का टाइम?
You are not aware. कुछ नहीं पता है. FA number 264 of 2023. कोर्ट फीस भी नहीं फाइल करते.
4 weeks.
Counsel for the appellant prays for and is granted time till 6th of February 25 to remove the surviving defects / file appropriate interlocutory application in connection with one or the other defect. Preemptory. If the order is compliant, post this case on 11th of February in the supplementary post list.
Item 2, first appeal 305 of 2023.
In relation to this matter, we have received directions from SAIL to appear in the matter. Copy has also not been served to us, so I'm requesting if our name may be, if Mr. Indrajit Sinha's name will be reflected.
There is only one defect remaining with regard to seal of the company at the Wakalatnama number.
1 and 4.
One has been removed right now by filing court fee. Rupees 250.
First appeal number 305 of 2023. Learned counsel for the appellant has submitted that the defect number 1 has been removed during the course of the day. And so far as defect number 4 is concerned, he undertake to remove the same
Within a week. Within a week.
remove the same within a week. MS Prerna Jhunjhunwala submits that MS Prerna Jhunjhunwala JC to Mr. Indrajit Sinha submits that she would accept notice on behalf of the sole respondent in this case. She undertakes to file wakalatnama within a week. Within a week.
We can serve a copy of the memo of appeal.
Counsel for the appellant is directed to serve a copy of the memo of appeal along with its enclosure to the learned counsel for the respondent by within a week.
And senior's name will be reflected in the.
अभी नहीं, बिना वकालतनामा के किसी का नाम नहीं रिफलेक्ट कर सकते. pose this case on thirteenth of February.
Well, it can come,
In the sorry,
it can come next week, but it is to be formally admitted and LCR is to be called for.
आप चिंता मत करिए, LCR अभी कॉल कर लो, इसीलिए रखें 13th of February 2025. In the meantime, the records we called for from the concerned group. कहाँ से है?
It is from Giri.
Upon deposit of special messenger
Bhutan.
cost. Upon deposit of special messenger cost by the appellant. मनी सूट कितना ही पेंडिंग रहेगा, अब बस तैयारी करें.
Item 3, first appeal 114 of 2024.
Yes.
In this case, your lordship, I appeal for 2 weeks time for remove the defect, except your lordship serial number 21. Because your lordship in serial number 21, the decree will do all and it would below for necessary correction.
डिफेक्ट नंबर 1 क्या है?
Defect number 1 is regarding about judgment and decree.
सर्टिफाइड कॉपी आप फाइल ही नहीं करेंगे तो क्या
I
ही
will,
होने
I
वाला?
will file it today, your lordship.
फाइल कल ऑर्डर करेंगे. You have got it, no?
Yes, your lordship.
FA number 114 of 2024. Learned counsel for the appellant undertakes to remove the defect number 1 with regard to filing of certified copy with authentication fee during the course of the day. He also undertakes to remove the remaining defects within a period of 15 days from today. So far as defect number 21 is concerned, once the certified copy of the judgment is filed, the office is directed to send back the same to the concerned court for necessary correction. Pose this case on February 13th under appropriate heading. बाकी सब कर लीजिए.
Yes, your lordship.
Item 4, first appeal 120 of 2024.
Yes, appellant.
4 weeks time may be granted for removing the defect. There is a defect of court fee of 47,000. One is supplementary affidavit that also will file in the same day. 47,000.
टाइप कॉपी फाइल करने के लिए 4 weeks तो नहीं चाहिए, ठीक है. One is regarding filing of typed copy. Other is statement regarding annexures are 2 copies. इसके लिए supplementary फाइल करना है और court fees फाइल करना है, ठीक है. FA number 120 of 2024.
Your lordship, perhaps, type copy. 2 weeks for type copy. For court fee, I am seeking. So in total 4 weeks may be granted. I will remove all the defects.
It's a company bankrupt तो नहीं हुआ है, फाइल कर लिया,
Company basically
bankrupt हो गए.
खत्म ही हो गया because they had incurred a loss of 30 lakhs rupees and they closed down the entire business. They faced problem, that is why.
Counsel for the appellant prays for and is granted time till 6th of February 25 to remove the surviving defects preemptory. If the defects are removed within time, pose this case under appropriate heading on 11th of February. Preemptory order है, comply कर लीजिए.
For hearing under order 41 rule 11. Item 5, second appeal 56 of 2020.
आज भी लिया था.
बहुत अच्छी बात है.
This appeal is preferred against the judgment dated 27/9/19, degree sealed and signed on 6/11/19. In civil appeal number 4/12, asked by Sri Kumar Dinesh Lalne, District Judge to Giridih, confirming the judgment degree dated 14/11/2011, degree sealed and signed on 22/11/2011, in title suit number 14/1982, passed by Sri Sukhpal Singh, learned subject Giridih appellant defendant above also. Not in this case, only two questions arise: whether Surendra Nath is the own son of Kausalya Devi or not. This issue has not is decided in favor of plaintiff. However, the position as well as other documents shows that Surendra Nath is the step son of Kausalya Devi. Whole suit is decided upon only this point. And second is that your lordship earlier mortgage land which was got by the defendant in 1980, what was in the which is not challenged by any appeal or other things, and same is decided in this suit, that is null and void, property is this. Only 2 points on my
Is there any legal bar?
Yes,
The-
लीगल बार एक बार हुजूर इसको देखा जाए, पहले यहाँ आते हैं।
He was not a party in the suit.
इसलिए कि वो उनका बेटा नहीं था,
हाँ, तो
इसलिए
इसीलिए
कि उनका वो बेटा नहीं था,
जब वो
इसलिए
पार्टी नहीं थे सूट पे, तब वो तो सूट डिक्री नहीं चैलेंज करेंगे ना, राइट?
हाँ, तो
His entire case is that he was not made party in the suit, and therefore the suit was wrongly decreed.
wrongly decreed. However, it is it true, then it was adverse possessions 80 के बाद सूट 11 में आया है।
एडवर्स पोजीशन का प्ली लिया है क्या आप तो ऑक्शन परचेजर हैं।
ऑक्शन परचेजर है,
एडवर्स पोजीशन का क्या बात?
सॉरी लॉन्ग पोजीशन, लॉन्ग पोजीशन 80 मेरे पास 2011 में सूट में गए हैं।
लॉन्ग पोजीशन से एडवर्स पोजीशन नहीं होता।
एक बार इसको देखा जाए, पहले यहाँ से आते हैं, पेज 38 रनिंग
लॉन्ग पोजीशन से एडवर्स पोजीशन नहीं होता, ठीक है?
38 पे में देखा जाए।
बताइए। पहले आपका ये जो फाइंडिंग है रिगार्डिंग सन,
मन
ट्रायल कोर्ट का क्या फाइंडिंग है और क्या इशू बताइए ट्रायल कोर्ट में क्या?
ट्रायल कोर्ट में इशू है, इशू नंबर 9, क्या सुरेंद्र नाथ कौशल्या देवी का लड़का था,
हाँ।
एक ये, और इशू नंबर 7 में क्या मॉर्गेज सूट 68/71/38/73 सब्जेक्ट गिरिडीह द्वारा पारित की गई डिग्री विविध विरुद्ध अवैध और शून्य।
इशू नंबर 9 का डिस्कशन दिखाइए ट्रायल कोर्ट।
डिस्कशन दिखा रहे हैं हुजूर, पेज नंबर 44 रनिंग पेज नंबर 9, ये पारा 8 में रनिंग पेज, इनर पेज 9 रनिंग पेज 44।
पढ़ी।
वाद बिंदु संख्या 9, क्या सुरेंद्र नाथ कौशल्या देवी का पुत्र था? उक्त वाद बिंदु के आलोक में विलेख का उल्लेखन किया गया। वादी ने अपने वाद में स्पष्ट रूप से लिखा है कि वह महावीर प्रसाद की पुत्री कौशल्या देवी का पुत्र है तथा कौशल्या देवी की मृत्यु होने के बाद उनके पिता विश्वनाथ प्रसाद द्वारा दूसरी शादी की गई, जिससे महेंद्र नाथ वादी का सौतेला भाई हुआ। स्वयं पतिवादी ने अपने लिखित प्रति उत्तर में कहा कि उन्होंने स्थानीय लोगों से महावीर प्रसाद के वारिसान के संकारी की तो उन्हें पता चला कि महावीर प्रसाद को 2 लड़के एवं 6 पुत्रियां थी। कौशल्या देवी के साथ विश्वनाथ प्रसाद की शादी हुई थी और कौशल्या के विश्वनाथ को महेंद्र नाथ पुत्र हुआ था, ये इम्पोर्टेंट है। इस प्रकार सुरेंद्र नाथ महावीर प्रसाद का नाती नहीं है। वादी द्वारा अपने
नहीं एक सेकेंड।
हाँ,
विश्वनाथ प्रसाद एक सेकेंड, ये आपने अपने WS में ही लिखा है, ठीक है
जी,
कि उन्हें स्थानीय लोगों से पता चला कि महावीर प्रसाद के वारिसान के संबंध में जानकारी की तो उन्हें पता चला कि महावीर प्रसाद के 2 लड़के एवं 6 पुत्रियां, राइट, 2 सन्स।
हाँ, तो कौशल्या
एक सेकेंड, कौशल्या देवी के साथ विश्वनाथ प्रसाद की शादी हुई थी,
जी
राइट?
जी
और कौशल्या देवी से विश्वनाथ को
को
महेंद्र
महेंद्र नाथ पुत्र हुआ था,
ओके, और ये किसका क्या नाम है?
ये सुरेंद्र नाथ।
अच्छा,
इस प्रकार सुरेंद्र नाथ महावीर प्रसाद का नाती नहीं है, जिस पर ये टाइटल अपना क्लेम कर रहे हैं।
ओके।
सुरेंद्र प्रसाद
महेंद्र नाथ का पार्टी बनाया था आपने
जी।
उसमें
जी।
प्रीवियस रूप में।
जी
आगे बढ़िए।
उसके बाद वादी द्वारा अपने कथन के समर्थन में वादी संख्या 1 विश्वनाथ प्रसाद की साक्षी के प्रस्तुत किया गया, जो वादी के पिता भी हैं। उन्होंने अपने मुख्य परीक्षण में पैरा 2 में स्पष्ट रूप से स्वीकार किया है कि उनकी पहली शादी महावीर प्रसाद की लड़की कौशल्या देवी के साथ हुई थी। उन्हें पहली पत्नी में एक लड़का पैदा हुआ था जो वादी है, ये यहाँ बोलते हैं अपना में। वादी संख्या 2 अपने मुख्य परीक्षण में, वादी संख्या 2 पैरा 2 में
ये जो है वादी संख्या 1, ठीक है ना, जो PW1 है वो उनके पिताजी हैं।
महावीर प्रसाद के ये भी बेटे हैं, लेकिन ये सौतेले बेटे हैं।
PW1 का नाम क्या है?
PW1
विश्वनाथ प्रसाद।
विश्वनाथ प्रसाद जो फादर हैं सुरेंद्र नाथ और महेंद्र नाथ दोनों का,
है ना
जी।
तो वो खुद ही बोल रहे हैं कि मेरे बेटे हैं।
हाँ, उनका बेटे हैं, कहाँ, बट कौशल्या देवी के बेटे नहीं।
कहाँ ऐसा? उन्होंने अपने मुख्य परीक्षण में पैरा 2 में स्पष्ट रूप से स्वीकार किया है कि पहली शादी महावीर प्रसाद की लड़की कौशल्या देवी के साथ हुई थी और उन्हें पहली पत्नी से एक लड़का पैदा हुआ है जो वादी है।
ये यहाँ ही बोलते हैं।
हाँ,
आगे आइए। उसके बाद वो जो और उन्हें पहली पत्नी से एक लड़का पैदा हुआ जो वादी है। वादी संख्या 2 अपने मुख्य परीक्षण के पैरा 2 में स्पष्ट रूप से कहा विश्वनाथ बाबू को पहली पत्नी से एक लड़का पैदा हुआ था जो सुरेंद्र नाथ, ये बोलते हैं। वादी संख्या 10
तो
भवानी शंकर,
ये भी सपोर्ट कर दिए हैं।
हाँ, मुझे तो दोनों चूंकि शूट करने को।
ओके।
हाँ, वादी संख्या 10 भवानी शंकर प्रसाद जो वादी के मामा मुख्य परीक्षण से कहते हैं कि मेरी बहन कौशल्या देवी की शादी विश्वनाथ प्रसाद जिन्हें एक लड़का सुरेंद्र नाथ ही भी बोले हैं।
ठीक है।
पैरा 3 में यह भी कहा गया है कि मेरी बहन के मरने के बाद बहनोई विश्वनाथ प्रसाद दूसरी शादी किए जिससे एक लड़का सुरेंद्र प्रसाद है। ये इम्पोर्टेंट है, वो इसी पैरा में आते हैं। मरने के बाद जो दूसरी शादी किए उससे लड़का सुरेंद्र प्रसाद है। सुरेंद्र नाथ जो इस वाद में स्वयं वादी ने अपने मुख्य परीक्षण में कहते हैं कि महावीर प्रसाद हमरे अपने नाना थे, ये बोलते हैं। मेरी माँ के देहांत के बाद पिताजी दूसरी शादी किए जिसे महेंद्र किशोर हुए, ये कहते हैं। जो मेन बेटा है उसको ये कहते हैं कि वो सौतेला है, उसकी कौशल्या देवी का नहीं। अभी आगे वो बढ़ते हैं। इस प्रकार अपने वाद में किए गए कथन का साक्षी द्वारा समर्थन किया गया था। वादी संख्या 12 महेंद्र किशोर जो स्टेप ब्रदर है, अपने मुख्य परीक्षण के पैरा 1 में कहते हैं जो स्टेप पर कि सुरेंद्र नाथ मेरे सौतेला भाई हैं तथा अपने नाना का नाम दिलावर लाल बोलते हैं वो सुरेंद्र, माता का नाम सावित्री देवी बताए। प्रतिवादी संख्या 1 मुख्य परीक्षण में कहते हैं कि सुरेंद्र नाथ कहकर भी महावीर बाबू का एक नाती है। कहते हैं कि महावीर बाबू को सुरेंद्र नाथ नाती नहीं है, ये भी आया है इनका मुख्य परीक्षण में कि सुरेंद्र नाथ नाती नहीं है महावीर बाबू का, जिनकी बेटी कौशल्या देवी है। प्रतिवादी साक्षी संख्या 2 नारायण प्रसाद वर्मा अपने प्रति परीक्षण के पैरा 10 में स्वीकार करते हैं कि सुरेंद्र नाथ को हम नहीं जानते हैं, महेंद्र नाथ को देखा है। प्रतिवादी साक्षी संख्या 3 निर्मल कुमार जो प्रतिवादी साक्षी संख्या 1 है। निर्मल कुमार विश्वनाथ प्रसाद की ओर से पावर ऑफ अटॉर्नी मिला होने की बात करते हैं और वे पिताजी की ओर से मुकदमे का देखभाल भी करते हैं। अपने मुख्य परीक्षण पारा 3 में कहते हैं, महेंद्र नाथ को जानता हूं, वह कॉलेज में हमारे साथ पढ़ा था। महेंद्र नाथ महावीर बाबू के लड़की का लड़का है। सुरेंद्र नाथ क्लेम करते हैं कि हम कौशल्या, और ये बोलते हैं कि महावीर बाबू का के लड़की का लड़का है, मतलब कौशल्या देवी का लड़का महेंद्र नाथ है। पैरा 4 में यह भी कहते हैं कि मॉर्गेज का 6871 दायर करने से पहले महावीर बाबू के वारिसान को नोटिस दिया गया था। यह कार्बन कॉपी है जिसे वरीय अधिवक्ता गोविंद प्रसाद का हस्ताक्षर है। कार्बन कॉपी प्रदर्श, इसे प्रदर्श भी अंकित किया गया है, एग्जिबिट 2। तथा पैरा 5 में यह भी कहा गया है कि मॉर्गेज मुकदमा 6871 में महावीर बाबू के सभी वारिसानों को पार्टी बनाया गया था। निष्पादन के लिए इजराय की मुकदमा किया जिसमें महावीर प्रसाद के सभी वारिसानों को नोटिस कराया था, उसका भी गजट भी हुआ था। इस प्रकार अभिलेख के अवलोकन से स्पष्ट है कि सुरेंद्र प्रसाद कौशल्या देवी का लड़का है। यहाँ ही बोलते हैं अभिलेखन से सुरेंद्र प्रसाद कौशल्या देवी। इस बिंदु पर उसके पिता वादी संख्या 1 एवं मामा कथन महत्वपूर्ण है, जो कि कहते हैं कि सुरेंद्र नाथ कौशल्या देवी का लड़का। यहाँ ये आ गया है दूसरे में। प्रतिवादी पक्ष की ओर से ऐसा कोई भी साक्ष्य अभिलेख प्रस्तुत नहीं किया गया, मतलब डिफेंडेंट मेरे तरफ से, और उसी में ये उनके फेवर में कर दिया गया। जबकि सुरेंद्र नाथ कौशल्या देवी का अपना बेटा नहीं, आगे भी आया है वो।
देखिए सेकेंड अपील में इतना रीएप्रिसिएशन ऑफ एविडेंस नहीं होगा, परमिशन नहीं है ऐसा करने का।
उसके बाद है हुजूर मॉर्गेज जो हुआ था, मॉर्गेज केस हुआ था, हम नीलामी इसमें लिए हैं 1980 में।
वो बात ही नहीं है ना, बात ये मॉर्गेज सूट में पार्टी नहीं बनाया, therefore it is not
इसलिए
binding.
कि he was not necessary party. He was not necessary party. महेंद्र प्रसाद was made party as because कौशल्या देवी का वो वारिसान है। इस ग्राउंड पर हमने उसको पार्टी बनाया था। और सूट डिसाइड हुआ है फाइनल डिग्री हुआ है 6/6/1977 को। इसमें एक बार हुजूर हम रिटन स्टेटमेंट देख लेते, मेरे पास वो नहीं है, हम बोले हैं आज वो भेजेंगे।
आधा घंटा बहस करने के बाद ये सब परमिशन नहीं है।
तो हम कल बोले आज चूंकि करना था, कई बार
हर डेट में एक डेट में आपको फाइल देंगे, 3 डेट में
नहीं,
आपका
फाइल
फाइल
हमको
गुम हो
मिल गया,
जाएगा।
मेरा फाइल मिल गया, हम बोले थे
बहुत अच्छी, बहुत बड़ा कृपा किया है आपने हमारे ऊपर, ये आपको फाइल मिल गया।
आप
क्या ही बोलते हैं आप, आपको फाइल मिल गया तो आपके पास रिटन स्टेटमेंट नहीं है, इसको एग्जामिन करने के लिए एक दूसरा डेट देंगे आपको। यस,
केस तो लड़ रहे हैं हम, अपने लिए लड़ रहे
बहुत
हैं।
अच्छी बात है, लग तो नहीं रहा है कि अपने लिए लड़ रहे हैं।
जो हुजूर समझा, हम इसमें क्या बोल सकते हैं। जो ऑक्शन में खरीदा गया था 17/1/1980। एक बार पारा 11 देखा जाए, इशू नंबर 7 पेज 46, वाद बिंदु संख्या 7, मॉर्गेज सूट नंबर 100 का पारित की गई डिग्री, ये भी उन्हीं के फेवर में वहाँ अलाउ किया गया, जिसको कन्फर्म किया गया था, यही भी रखा। उस मॉर्गेज सूट को कहीं चैलेंज नहीं किए इन लोग को,
नहीं करेंगे ना, पार्टी नहीं है,
बाकी लोग भी नहीं किए,
बाकी लोग
नॉट ओनली
उससे क्या लेना देना,
दिस प्लेंटिफ।
उससे क्या ही लेना देना।
यहाँ जो 47 में है कि मॉर्गेज सूट नंबर बीच में 8/68/71 को दायर करने के पहले महावीर प्रसाद के वारिसानों को एक विधिक नोटिस जारी किया था, जिसे प्रदर्श बी में अंकित कराया है। लीगल नोटिस जो हम लोग दिए थे वो, एवं प्रदर्श ए द्वारा महावीर प्रसाद के वारिसान भवानी प्रसाद शंकर का हस्ताक्षर प्रदेश करते हुए कहा कि नोटिस भवानी शंकर को प्राप्त हो गया था। मतलब अर्लियर देन सुरेंद्र नाथ के पहले का जो वारिसान थे उनको उस समय नोटिस करा दिया गया था। भवानी शंकर वारिसानों को सूचना में उपस्थित होकर अपना लिखित प्रतिउत्तर दाखिल नहीं किए, उसके बावजूद वो लोगों ने कोई उत्तर दाखिल नहीं किए। एक पक्षी सुनवाई करते हुए डिग्री पारित किए हैं। वादी द्वारा प्रस्तुत साक्षी संख्या 10 भवानी शंकर प्रमुख परीक्षण पारक स्वीकार करते हैं कि नोटिस मिलने के बाद किया गया
कौशल्या देवी महावीर प्रसाद की कौन थी?
पुत्री
डॉक्टर।
और कर्जा चुकाने का प्रयास किया गया। 2-3 साल तक प्रयास किया। पैरा 14 में यह भी कहते हैं कि नोटिस हमको मिला था, उसका जवाब नहीं दिया गया। ये स्वीकार करते हैं वारिसान लोग महावीर प्रसाद का वारिस। और कर्जा 2-3 साल के लिए दिया गया था चुकाने, जो नहीं चुका पाए। एक बार इसको देखा जाए, पेज इनर पेज 5 पेज 14 बॉटम में स्थानीय लोगों से पूछताछ करने पर पता चला कि कौशल्या देवी महावीर प्रसाद की लड़की थी, जो अपने मृत्यु के समय एक लड़का महेंद्र प्रसाद को छोड़कर मरी थी और वह वर्तमान वादी को नहीं जानता है। ये स्थानीय लोगों का आया है।
Who was defendant number 1?
डिपेंडेंट नंबर 1 इज विश्वनाथ साहबादी, उनका सब्स्टिट्यूशन में दीजिए पिलांट आर द
Defendant number is विश्वनाथ प्रसाद।
विश्वनाथ प्रसाद साहबादी, उसका बेटा, ये इन लोग सब्स्टिट्यूट किए हैं। बेटा बेटी मिला के 5, 6, 7, 8 जो एपिलेंट है इसमें।
Just a moment. ये प्लेंटिफ के फादर का क्या नाम है?
प्लेंटिव के फादर का नाम वो सुरेंद्र नाथ ही लिखते हैं।
प्लेंटिफ के फादर का नाम।
प्लेंटिव का, अच्छा सुरेंद्र नाथ। इसमें एक
सुरेंद्र नाथ का सब्स्टिट्यूट हुए थे क्या?
हाँ सब्स्टिट्यूट नहीं,
सुरेंद्र
प्लेंटिव पे
नाथ-
है सुरेंद्र नाथ, प्लेंटिव पे है इसमें।
वही तो, सुरेंद्र नाथ का तो नाम नहीं दिख रहा। 1A 1B 1C। सुरेंद्र नाथ के पिताजी का क्या नाम?
तो सुरेंद्र नाथ के भी पिता उनका भी नाम वैसे विश्वनाथ प्रसाद,
वही
चूंकि
तो दोनों का सेम नाम है।
हाँ, चूंकि स्टेप सन है, जब कौशल्या देवी डेथ कर गई तो
चूंकि का कहानी मत सुनाइए आप हमको, दोनों का नाम सेम।
नेचुरली रहेगा। कौशल्या देवी पर यहाँ केस है, विश्वनाथ प्रसाद पर केस नहीं। विश्वनाथ प्रसाद महेंद्र प्रसाद के भी फादर हैं और सुरेंद्र नाथ के भी फादर।
विश्वनाथ प्रसाद डिफेंडेंट थे।
वो विश्वनाथ प्रसाद अलग है।
वही ना, दो विश्वनाथ प्रसाद है ना इसमें।
डिपेंडेंट जो है विश्वनाथ प्रसाद साहबादी, वो उनका अभी जो
देखिए, ये
एपिलेंट
आप जो
है।
बीच में एक तो वर्ड घुसा रहे हैं ना, वो आपके जजमेंट में कहीं नहीं दिख रहा है। विश्वनाथ प्रसाद खाली दिख रहा है।
हाँ,
तो
तो वही
बीच में एक तो
उनका
कौन सा सरनेम आप घुसा रहे हैं? क्या बोल रहे हैं आप? विश्वनाथ प्रसाद, ऐसा तो कुछ नहीं है।
विश्वनाथ प्रसाद है, मतलब वही साहबादी, इनका जो निर्मल साहबादी फादर का नाम विश्वनाथ प्रसाद है। और एक डिफेंडेंट इनके जो सुरेंद्र नाथ हैं, उनके फादर की नाम भी विश्वनाथ प्रसाद। ये चीज कर
हाँ जी, तो दो अलग आदमी है ना,
हाँ,
दो विश्वनाथ प्रसाद है इसमें।
दो अलग आदमी हैं।
एक
कौशल्या
विश्वनाथ
देवी के
प्रसाद,
कौशल्या देवी के हस्बैंड हैं
उनका
विश्वनाथ
भी नाम
प्रसाद।
विश्वनाथ प्रसाद है।
हाँ, और जो
डिफेंडेंट
मॉर्गेज
नंबर
प्रॉपर्टी
1 है,
खरीदते हैं वो भी है
वो
विश्वनाथ।
भी विश्वनाथ प्रसाद। परचेजर ऑफ द प्रॉपर्टी इज आल्सो विश्वनाथ
विश्वनाथ
प्रसाद।
प्रसाद।
फादर ऑफ द प्लेंटिफ इज आल्सो विश्वनाथ
विश्वनाथ
प्रसाद।
प्रसाद।
Father of the plaintiff has been examined as PW1. सावित्री पिताजी ने कहा है कि सावित्री देवी से उनको महेंद्र नाथ का जन्म हुआ है।
ये यहाँ वो बोले हैं, लेकिन जो बाकी लोग बोला है
बाकी
ग्रामीणों,
लोग पिताजी से बेहतर कौन बताएगा?
पिताजी चूंकि लोग में बोल रहे हैं,
लोग में बोल रहे हैं, अच्छी बात है।
स्थानीय लोगों से पूछताछ करने पर पता चला कि कौशल्या देवी महावीर प्रसाद की लड़की थी और अपने मृत्यु के समय एक लड़का प्रोफेसर महेंद्र प्रसाद को छोड़कर वो मरी थी। वर्तमान में वादी को नहीं जानता। वहाँ के जो लोग हैं, यह भी मान लिया जाए कि सुरेंद्र नाथ महावीर प्रसाद का एक उत्तराधिकारी था, तो यह नहीं कहा जा सकता है कि मॉर्गेज में को प्रतिनिधित्व नहीं था, चूंकि उस समय ये नोटिस उटिस किया गया था, बाकी लोग अपीयर किए थे महेंद्र प्रसाद। और ये भी पार्टी जो बनाए हैं अपना सूट में,
आप देखिए पेज नंबर 26, इंटरनल पेज 12 ऑफ द appellate court's judgment.
पेज 12, पारा 11,
DW1. But DW1 has admitted in his para 3 that Surendranath is also a grandson of Mahabir Babu And again, he has stated that Surendranath is not the grandson of Manu.
ग्रैंडसन है ही है, हम कहाँ बोल रहे हैं, बट नॉट सन ऑफ कौशल्या देवी। सब्सिक्वेंट शादी हुआ, वो ग्रैंडसन तो है ही है, उसका डिनाई हम भी नहीं करते।
तो भी महावीर बाबू के अगर ग्रैंडसन है तो लीगल हियर सक्सेसर तो हो गए ना उनकी
नो नो
property के?
महावीर बाबू का बेटी का बेटा नहीं है वो अपने ग्रैंडफादर का ग्रैंडसन है।
ग्रैंडफादर का तो ग्रैंडसन
हाँ,
ही होगा।
तो इसलिए मदर दो हो गई ना, मदर दो हो गई उसके। सुरेंद्र नाथ दूसरी माँ का है, कौन देवी है, सावित्री देवी के सन है, ये मेरा कहना। सुरेंद्र नाथ इज द सन ऑफ सावित्री देवी। इसलिए PW1 में वो ठीक बोले कि मेरा नाम ये है। भवानी शंकर इज अदर पार्ट ऑफ द लैंड योर लॉर्डशिप। ये देखिए साक्षी संख्या 10 भवानी शंकर प्रसाद जो और को शेयरर हैं उस लैंड का, उन्होंने बोला कि मुख्य परीक्षण के पारा 13 में स्वीकार करते कि नोटिस मिलने के बाद लिया गया कर्ज चुकाने का प्रयास किया था, 2-3 साल तक प्रयास किया। पैरा 14 में यह भी कहते हैं कि नोटिस हमको मिला था, उसका जवाब नहीं दिया था। याद नहीं है कि इस नोटिस में हमारे अलावे बहुत से लोगों का नाम था। प्रतिवादी संख्या 3 निर्मल कुमार अपने मुख्य परीक्षण पैरा 4 में कहते हैं मॉर्गेज सूट दायर करने के पहले हमने महावीर प्रसाद के वारिसानों को नोटिस किया था, तथा पैरा 5 में यह भी कहते हैं कि सुधभरना मुकदमा 68-71 में महावीर प्रसाद के सभी वारिसानों को पार्टी बनाया था। प्रतिवादी द्वारा प्रदर्श बी में एग्जिबिट बी में कराए गए नोटिस के अवलोकन से स्पष्ट है कि प्रदर्श बी में क्रम संख्या 6 पर श्री महेंद्र प्रसाद पिता विश्वनाथ प्रसाद को नोटिस किया गया था। महेंद्र प्रसाद जो रियल सन ऑफ कौशल्या देवी हैं, उनको नोटिस किया गया था। उसमें वादी सुरेंद्र प्रसाद का नाम नहीं है। इस प्रकार अभिलेख अवलोकन से स्पष्ट होता है कि मॉर्गेज सूट 68-71 नाम में सुरेंद्र नाथ को प्रतिवादी संख्या 1 के द्वारा उचित ढंग से नोटिस नहीं किया, ये उनके द्वारा कहा गया। जटाशंकर प्रसाद और भवानी प्रसाद दो सन है महावीर प्रसाद
आपको बोलना है।
ना, हमको क्या बोलना है?
Second appeal number 56 of 2020. For the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that although there are concurrent findings recorded by the learned courts, but the learned courts have wrongly come to a conclusion that Suren Nath, the plaintiff, was son of Kaushalya Devi. He has submitted that the issue as to whether Suren Nath was son of Kaushalya Devi was the main issue involved in this case, inasmuch as the entire case revolved around the fact that Suren Nath was not made a party in the earlier suit, which was a mortgage suit number
6871 of 2000 68/71/38/73
mortgage suit bearing number 68 of 1971/38 of 1973. the Learned Council has submitted that the impugned judgments call for interference by forming substantial question of law and by holding that the holding that in the mortgage suit the plaintiff, namely Suril Nath, was not a necessary party as he was not the son of Kaushalya Devi, correct? After hearing the Learned Council appearing on behalf of the appellant, this court finds that title suit number 14 of 1982 was filed, whereby the plaintiff claimed 1/8 share of the suit property and also sought a declaration as void with respect to the decree passed in mortgage suit number 68 of 1971/38 of 1973 and also the auction passed in execution case number 9 of 1977.
एक चीज बीच में बोलते हैं, शाहबादी लिखा हुआ है, इन लोग का जो नाम है इसमें इम्प्यूग जजमेंट में देखा जाए तो सभी पिता विश्वनाथ प्रसाद शाहबादी।
The learned trial court framed the following issues for consideration. A written state, the specific case of the plaintiff was that the suit property in Schedule B was acquired by Mahavir Prasad, who died in jointness with his descendants on 4/167, leaving behind his 2 sons and 6 daughters, including Kaushalya Devi, who came in joint possession of the suit property after his death. It was his case that one of the son of Mahavir Prasad died in 1973 in the state of jointness with his brothers and sisters. And Another sister died in the year 1967. Leaving behind two sons who were defendant number 5 and 6 in the suit. The daughters of Mahavir Prasad, the other daughters of Mahavir Prasad and defendant number 4, 7 and 8 had full right, title and interest over the property. The plaintiff gave the entire family history and stated that daughter of Mahavir Prasad, that is Kaushalya Devi, died leaving behind her only son Surendranath, the plaintiff, and her husband was Vishwanath Prasad. And accordingly, the plaintiff claimed that he had every right, title, interest and possession over the property which was joint property of heirs of Mahavir Prasad. It was his case that on 23/1/1982, he came to know that the suit property described in Schedule B has been auctioned by the court. And in favor of defendant number 1, whose name was also Vishwanath Prasad. As Vishwanath Prasad Vishwanath Prasad and the property was sold in mortgage suit number 68 of 1971, which was later transferred in the court of Sub-Judge Giridi and was renumbered as mortgage suit number 38 of 1973. It was his further case that the Sub-Judge Giridi passed a preliminary decree on 30/2/1975 ex parte, and final decree was prepared on 6/6/1977. The specific case of the plaintiff was that the defendant number 1, that is Vishwanath Prasad, obtained ex parte decree in the mortgage suit by playing fraud upon the court, as all the legal heirs of late Mahavir Prasad were not impleaded as parties in the mortgage suit. It was also asserted that the interest of the minor defendant, namely Rajendra Prasad, was not properly safeguarded. And the suit was barred on account of non-joinder and misjoinder of necessary parties. It was also asserted that the defendant number 1, within bracket Vishwanath Prasad, had filed execution case number 9 of 1977, in which he himself bought the property in court auction on 17/1/1980. The valuation of the property was not also fixed in accordance with law. There were altogether 3 bidders in the auction. One, Narayan Prasad, who was the partner of Vishwanath Prasad, within bracket defendant number 1. Another bidder was Vishwanath Prasad, the decree holder himself. And the third bidder was none was the but the Kapardaj of the decree holder, and the suit property was auction sold for an amount of rupees 35,000, although the valuation of the property was more than rupees 1 lakh. The cause of action arose on 23/1/1982 when the plaintiff came to know about the decree obtained by defendant number 1 Vishwanath Prasad in mortgage suit. The defendant number 1 had appeared and filed written statement by stating that Professor Mahendra Prasad was the son of Kaushalya Devi, who was not made party in the suit, and the descendants of all daughters of Mahavir Prasad were necessary parties, but they were not impleaded as parties in the suit. And Kausalya Devi was one of the daughters of Mahavir Prasad, who died leaving behind her only son, Professor Mahendra Prasad, and not the plaintiff Surendranath. It was also asserted that the plaintiff had full knowledge about the mortgage suit and its execution. And the valuation of the suit property was properly fixed at the time of auction. And therefore, there was no cause of action for the suit, and the suit was liable to be dismissed. The learned trial court framed the following issues for consideration. Altogether 9 issues for consideration. इसको इंग्लिश ट्रांसलेशन करा लेंगे पेज नंबर 42 में, ठीक है, पैरा नंबर 5 ऑफ ट्रायल कोर्ट जजमेंट.
10, 18, 9, 18.
हाँ 10 issues. As per the learned counsel for the appellant, the 2 of the issues are important for consideration. One was issue number 7, which was as to whether the mortgage suit was null and void and against the provision of law, and whether Surendranath was son of Kaushalya Devi. This court finds that the learned court by considering the evidences on record dealing with all the evidences placed on behalf of the plaintiff and the defendants, recorded that the plaintiff was son of Kaushalya Devi and has made special reference to the and has also stated that and also held that the defendant did not bring any evidence to show that Surendra was not the son of Kaushalya Devi. Any material evidence, and ultimately recorded a finding that Surendra was son of Kaushalya Devi. So far as the degree of mortgage suit is concerned, the same was also considered by paragraph 11 of the trial court judgment, and the learned trial court, after considering the materials on record, held that the plaintiff, that in the mortgage suit all the legal heirs of Mahabir Prasad were not made party, as the plaintiff, son of Kaushalya Devi, was not made a party in the suit. And accordingly, it could not be said that mortgage suit was decreed by making all the legal heirs as defendants, and plaintiff had claimed that he was entitled for 1/8 share of the property, and consequently the decree passed in the mortgage suit was held to be not binding on the plaintiff, and was declared to be illegal and null and void, and the issue was decided in favor of the plaintiff. The learned trial court also considered the legality and validity of the auction which was concerned with issue number 8, and after scrutinizing the materials on record, held that the plaintiff that the plaintiff of the mortgage suit had himself bought the property in auction sale, and also held that the plaintiff, being that the plaintiff of the present case being entitled for 1/8 of the suit property, the auction sale was also held to be void. This court finds that the appellate court framed the following 3 points for determination, paragraph 8 of the appellate court judgment. While considering point number 1 and 2 together, the learned court scrutinized the materials on record and gave concurrent findings in connection with the fact that Surendranath was son of Kaushalya Devi. After scrutinizing the materials on record, and has also given a finding that the plaintiff having not been made party in the mortgage suit, the ex parte decree obtained in absence of the plaintiff was not binding upon the plaintiff, and thus the decree passed in the mortgage suit was illegal and void. With respect to the auction, the learned appellate court also recorded that the defendant number 1 in the case had obtained ex parte decree in mortgage suit in absence of the plaintiff. And also referred to the judgment passed in another title suit number 14 of 1982, wherein the process of execution was stayed but the execution was finalized on 21/1984, and the title suit was decided on 24/7/1987. The order of the execution case in execution case number 77 was held to be illegal and void, having been obtained by playing fraud, and it was held that the party that the same was not binding upon the plaintiff. The learned court has recorded that the learned trial court has rightly passed the judgment and decree in favor of the plaintiff based on evidences on record. After going through the judgments passed by both the courts, this court finds that both the courts have given concurrent findings of fact after appreciating the materials on record. The law is well settled that there is no scope for reappreciation of evidences at the stage of second appeal in absence of any perversity. The learned counsel for the appellant has not been able to point out any perversity in the impugned judgments, calling for formulation of any substantial question of law in this case. There being no substantial question of law involved in this case, this appeal is hereby dismissed.
From reading this item 2, second appeal 137 of 2020.
Yes. Whom are you representing?
By mistake.
Why a counter affidavit was called for? Why was there a need for filing a counter affidavit? Why are you silent? Sorry?
I am not gone through
Why are you here then?
the first place was sort of asked.
Where is the appellant? लास्ट चांस हो चुका है, कॉस्ट भी हो चुका है, क्या ही बचा है? डिसमिस कर देते हैं, क्या ही करेंगे? बताइए, पढ़िए पढ़िए, जजमेंट पढ़िए।
I'm appealing law.
आइए,
I'm extremely sorry.
वो डिसमिस का नाम से आप लोग आए।
नहीं
पढ़िए क्या है?
Counter is of no relevance. Counter file having counter is of no relevance. Judgments are
No.
to relevant.
Counter has nothing.
He's claiming on the basis of unregistered settlement.
Yes.
This is his case.
Now lordship may kindly see.
आप बैठ जाइए, आपको सुनेंगे।
हम my lord.
This
कॉन्करेंट फाइंडिंग है, क्या है?
is lordship. This is my lords, the plaintiff's second appeal against the judgment of affirmance. Now lordship may kindly see. The plaintiff, my lord, filed title suit number 29 of 2000 against the defendants, praying therein, my lord, for declaration of title, confirmation of possession, and in the alternative for recovery of possession with respect to the suit lands, my lord, which has been fully described in Schedule A of the plan. Suit land is, my lord, 1.80 acres of plot number 584/3 of Khata number 43, situated at village Mugli D. PS Gola, district Hazaribagh. Now, my lord, the specific case of the plaintiff is that the father of the plaintiff number 1, namely, my lord, Mandal Mato, reclaimed the suit land, and subsequently, my lord, it was settled by the ex-landlord Milord, in favor of the father of the plaintiff number 1 by virtue of customary hukumnama coupled with grant of rent receipt followed by delivery of possession in the year 1931. And Milord, the settlee came into possession over the same.
From where do you say 1931?
31 Milord,
From where do you say?
it was settled Milord in Sambat 1987. Sambat 1987 meaning thereby in the year 1931.
ये हमको कहाँ से मिला?
ये हुजूर 1987 में 56 को सब्सट्रैक्ट किया जाएगा तो 31 है
56 सब्ट्रैक्ट
जी
होता है क्या?
जी सर
सेट फॉर्मूला है.
लॉर्डशिप
87 minus
माइनस 56 31
Okay.
settle lordship. Now lordship में kindly see the father of the plaintiff Milord, dad leaving behind two sons, namely Magan and Jagan. Now lordship, there was an amicable partition amongst two brothers, Magan and Jagan. And Milord, the plaintiff number 1 was allotted Milord schedule A property, and he came into possession over the same. Now lordship, the plaintiff number 1 sold lordship 90 decimals of
So
land.
Jagan did not come to the court.
No.
He has no grievance.
No. Lordship. The plaintiff number 1 lordship sold 90 decimals of land to his wife, that is Milord plaintiff number 2, by virtue of registered sale deed dated 9/4/1986. Total area is 1.80, out of which Milord the plaintiff number 1 sold 90 decimals of land to his wife, who is plaintiff number 2. And thereafter, Milord, on the eve of vesting of the estate under the provisions of Bihar Land Reforms Act 1950, demand with respect to the suit lands was opened in the name of the plaintiff number 1. And Milord, the plaintiff number 1 was recognized as Rayat by the estate, and rent receipts were duly issued in his favor. This is, Milord, the case of the plaintiff. Now, Milord, the defendant started laying false claim over the suit lands. Therefore, lordship, necessity of the suit.
Private parties are also there.
Lordship.
Okay.
Because, Milord,
The state is also there. The state filed its counter.
Lordship, defendants are the members of scheduled tribe. Therefore, Milord, Deputy Commissioner is a necessary party in view of the amended provision contained in Order
Did
1.
the Deputy Commissioner file any written statement?
Deputy Commissioner has not filed.
So private parties who are members of scheduled tribe, they file their
Lordship.
written statement. Are they the recorded tenant?
Lordship.
They are the recorded tenant.
No.
They are not the recorded tenant.
No, Lordship.
So under what capacity did they file
Lordship,
the
mechanism.
statement?
The case of the defendant number 1, 2, 3, they entered their appearance, Milord, and they filed written statement, defendant numbers 1, 2, 3. Now, Milord, their specific case in the written statement is that the lands measuring an area of 1 acre was settled with the father of these defendants by virtue of parcha granted by the subdivisional officer Hazaribagh on 15/9/1979. This is their case, that, Milord, the lands measuring an area of 1 acre was settled with the father of these defendants by virtue of grant of parcha by the subdivisional officer Hazaribagh on 15/9/1979. Now, Lordship may kindly see, this is important, paragraph 9 of the written statement. Now, Milord, in paragraph 9 of the written statement, the defendants have stated that suit land has nothing to do with the land of these defendants. Lordship may kindly see, this is important. Lordship may kindly see.
Just okay, where is the discussion in connection with the settlement?
I'm coming to that, Lordship.
We'll see that.
Lord. Now, my Lord, the learned trial court has disbelieved the settlement, the hukumnama, on the ground that there is no seal of the ex-landlord on the hukumnama. Now, Lordship may kindly see, from bare perusal, hukumnama has been exhibited as Exhibit 4. Now, my Lord, from bare perusal of Exhibit 4, it would appear that there is signature on the hukumnama and seal of the ex-landlord is not at all required. And thereafter, the name of the plaintiff was duly mutated in the revenue records and rent receipts were duly issued. Now, my Lord is aware, my Lord, that if settlement has been made by virtue of customary hukumnama, coupled with grant of rent receipt, followed by delivery of possession, it confers, my Lord, valid rayati right upon the settlee.
Para number 22 of the trial court judgment.
Lordship.
Para 22.
Yes. Hukumnama is not supported with any document. Har Zamin report, Kabuliyat, Jamindari rent receipt has also been filed.
What is the exhibit number?
Lordship may kindly say. Yes.
Exhibit 2 to 2 by D.
Lordship, Jamindari rent receipts, Lordship, Exhibit 2 series.
What are the dates of exhibit this?
Lordship may kindly see.
Just
Yes.
where is the discussion of exhibit 2 series?
1931,
Where is the discussion of exhibit 2 series?
2 series.
What was the title suit of 36 of 93? What was the title suit number 36 of 93? The court has recorded a finding that for the same and similar relief you had filed title suit number 36 of 93 which was dismissed by the municip.
Which is finally culminated into present suit.
No, page number culminated page इसमें आइए ना. Title suit number, a plea was taken that title suit number 36 of 93 was dismissed in connection with the same cause of action. And the further objection is that you have not sought any relief with regard to cancellation of the settlement made in favor
That is
of the
not
defendant.
required, Lordship. My Lord is aware, my Lord, that if a document is void, the same is not required to be challenged. And my Lord, the defendants themselves have stated that they have no manner of concern with the suit land. Where is the question of challenging settlement? And Lordship may kindly see, settlement has been made, my Lord, by virtue of customary hukumnama coupled with grant of rent receipt followed by delivery of possession. Therefore, it is a valid settlement in view of the judgment of this Honorable Court reported in 2005 volume 3 JCR page 211. And my lord, hukumnama is
2005 volume.
2005 volume 3 JCR page 211. Lordship may kindly see para.
This law is well settled.
Lordship.
There's no doubt about this. What happened before
And
the
Lordship,
appellate court?
the lower appellate court has held that since hukumnama is unregistered documents, therefore it cannot be relied upon. This is the finding of the first appellate.
They have also recorded a finding that the zamindari rent receipt is not the rent receipt of the disputed land.
Lordship may
What do you
kindly
have to
see,
say?
Lord. Even area has been mentioned, khata number has
You
been
just
mentioned.
see para number 25 of
I-
the appellate
I-
court judgment.
Lordship, it is an error of record.
Let us see para number 25 of the appellate court judgment.
Lordship. Of the trial court, Lordship.
No, appellate court.
Para number
25.
Jamindari rent receipts Exhibit 2B, Exhibit 2C and Exhibit 2D are not rent receipts of the disputed land. Now Lordship may kindly see the Jamindari rent
No,
receipt.
you see, read the discussion,
Yes.
para 25.
I also went through 4 government
No,
retail.
no, this internal page 12 of the appellate court judgment.
Yes.
The
There-
plaintiffs have filed 4 government rent receipts issued in the name of Hundal Mehto with respect to 1.80 decimal of land of Khata number 43 of village Muridi exhibit 1 to 1 by 2.
Yes, Lordship.
As well as 5 zamindari rent receipt exhibit 2 to 2 by 2.
Lordship.
You read it further on perusal of 3 zamindari rent receipts. Exhibit 2 by B, 2 by C and 2 by 2.
D are not rent receipts of the disputed land.
Now, it appears that they have been issued for 2.50 acres of land in Khata number 43. Yes, the plaintiff has stated in paragraph 26 of his deposition that the entire area of Khata number 43 is 7.72 acres and for area of dispute and the area of disputed plot is 1.80.
1.80 acres.
Then how this rent receipt has been issued for 2.50 acres?
Because my lord, I
There
have
is
I have
There is
stated-
no case of the plaintiff that apart from 1.80 acres land appertaining to Khata number 43, other areas of the are also being settled by Zamindar in the name of
No,
Hundal.
there is a specific pleading, Lordship may kindly see. There is a specific pleading. Lordship may kindly see.
No, you see, there is a finding that this particular rent receipt which you are saying was for 2.50 acres.
Which includes the suit lands.
No,
Lordship, which includes the suit lands.
no, the court says that where is the occasion of issuance of rent receipt for 2.50 acres?
Because
When, as per your case, the settlement was only for 1.80 acres.
settlement. So, and my lord, there is a
So
specific.
how the rent receipt could have been issued for 2.50
Because my lord,
acres?
other land has also been amalgamated.
Where-
There is a specific pleading.
where
Lordship,
is it?
Lordship may kindly see.
Where is it? Not
Yes,
only
yes.
pleading but also
Yes.
the evidence.
There is a specific pleading, Lordship may kindly see para 6. The plaintiff number 1 also amalgamated the suit land with his Rayati land situated towards the east of the suit land. Lordship may kindly see. There is a specific pleading.
Show me the plaint.
And my lord, the trial court has came to an erroneous finding that the suit will be governed by the provision contained in Article 59 of the Limitation Act. My lord is aware, my lord, that suit for declaration of title and recovery of possession is governed by the provision contained in Article 65 of the Limitation Act. This is not a case of cancellation of sale deed or any registered instrument. Therefore, Article 59 has got no application.
The court is saying so because you have not applied for cancellation of the settlement
Where-
issued in favor of the
Where,
respondent.
where is the, my lord is aware, my lord, if a document is void and the defendant himself has stated that we have no manner of concern with the suit land. This is the specific case of the defendant in the written statement. There was no occasion for challenging the settlement, my lord, made by the authorities. Therefore, my lord, finding of the first appellate court is wholly perverse while discarding, my lord, the hukumnama and rent receipt produced by the plaintiff. And rent receipt issued by the revenue authorities, my lord, is a document of possession as held by the Honorable Supreme Court, Lordship may kindly see, in the decision reported in 2024 Supreme Court, page 1064. Lordship may kindly see para 8.2. Recent judgment of the Honorable Supreme.
हर केस में आप लोग ऑर्डर 41 रूल 31 कैसे ले आते हैं? कॉन्करेंट फाइंडिंग
नहीं,
है
41,
discussion.
31 नहीं आएगा।
देखिए ना आप
अरे
सब्सटेंशियल क्वेश्चन ऑफ लॉ में
41, 31 नहीं आएगा। वो तो
Mechanical है।
वो तो रिवर्सल नहीं हुजूर, इन्वर्टेडली वो तो हुजूर 41, 31 रिवर्सल में आएगा।
देखिए heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that though there are concurring findings recorded by both the courts, but there are two substantial questions of law involved in the present case. Whether the learned trial court was justified, whether the learned courts were justified in rejecting the claim of title of the petitioner, of the appellant, based on Sada Hukumnama followed by issuance of Zamindari rent receipt, while rejecting the plea of the appellant based on Sada Hukumnama, and whether the learned courts have, whether the case would be governed by the provisions of Article 59 of the
Lots.
Indian Limitation Act or by Article 65 of the
Oblique. Lordship.
Indian Limitation Act. Right?
Lordship.
यही दोनों हैं.
बस.
This second appeal will be heard on the aforesaid two substantial questions of law. Issue notice to the respondent number. बताइए.
Respond number, Lordship, 1, 2, 3 and 5. My friend
1,
is
2, 3
appearing.
and 5. The respondent number 4 is represented before this court by the learned state counsel. Let the record through the notice through ordinary process as well as through registered government AG. The requisites be filed by Monday,
Tuesday, Lordship.
by Tuesday. Let the records be called for from the concerned court.
Highly obliged.
Pose this case under the heading for and pose this case on 20th of February in the supplementary cost.
After 30 days, Lordship.
After 30 days हो जाएगा 20 तारीख को.
जी. हुजूर एक
जी.
प्रेयर था हुजूर.
अभी स्टे नहीं करें.
नहीं स्टे नहीं मांग रहे. स्टे नहीं मांग.
बताइए.
एक हुजूर मेरा है आइटम नंबर 9.
अभी एडजर्नमेंट का प्रयास था.
एडजॉर्नमेंट नहीं होगी क्योंकि हम आज रेडी हैं, तबीयत ठीक
नहीं, कोई बात नहीं. देख
नहीं इसको
आपकी तबीयत एक केस के लिए ठीक है, दूसरे केस के लिए ठीक नहीं है. हम ऐसा बिल्कुल
मैडम ऐसा गलत कभी नहीं बोलेंगे. इसको केवल 1 वीक के बाद कर दिया.
कोई बात नहीं. केस कॉल आउट होने दीजिए. आपके साथ जूनियर कौन है?
I undertake to argue, Lordship. I undertake to argue. It may be taken up after 1 week, Lordship. I have some personal
नेक्स्ट
difficulty.
थर्सडे को कर देते हैं.
9 में हुजूर आइटम नंबर.
हाँ, आइटम नंबर 9 को नेक्स्ट थर्सडे में कर देते हैं.
हाँ कर दिया.
आप अपीलांट हैं?
जी.
अभी तक नोटिस नहीं हुआ है.
नहीं.
सेकेंड अपील है.
सेकंड अपील.
आइटम नंबर 9 को नेक्स्ट एट द रिक्वेस्ट ऑफ द लर्नड काउंसिल फॉर द अपीलांट.
अगले वीक में हुजूर कर दें.
हाँ, नेक्स्ट थर्सडे.
Obliged.
इसको मत रखिए, सब काम आने दो. चलिए.
Item 3, second bill 161 of 2020.
The appellant is the plaintiff made against a concurrent finding. Then it's short fact if I just place my name. In this case, it is a minor plaintiff had brought a suit for carving out 8/9 share in the suit property, which is a tank mine. And if my lord will find the basis of the case is that the recorded tenant, being minor, had surrendered by registered deed minor. If my lord will kindly come to the trial court judgment, so surrendered by registered deed minor to ex-landlord Muchiram Mahto on 28/6/1935. Page number, it will be my lord internal page 3 of the judgment. There where the fact has been detailed out, my lord, paragraph which is continuation. May I place it, my lord, this paragraph?
The plaintiff claimed. Let us see the case of the plaintiff
Yes, my lord. Paragraph
from the
is-
trial court judgment.
Yes, from trial court, my lord. It will be page 33,
Yes.
para 2, my lord. The case of the plaintiff as pleaded in their plaint in brief is that the land in plot number 169 are 68 decimal and 167 area 69 decimals. More fully described in the schedule below to Jilal Mandal of village Saharjori, and after his death his only son Asu Mandal came in possession of this land, including the other land left by Jalal Mandal. Asu Mandal, while he was minor, could not cultivate the land in the aforesaid plots and more fully described in the schedule below, surrendered the same to ex-landlord, namely Muchiram Mato, son of Ranjali Mato, on 28/6/1935 by registered deed of surrender, being deed number 2923, and left his claim over his land. Since the date of surrender, Muchiram Mato, being the tenure holder of Moja Tundaha, came in possession over the land mentioned in the schedule below and he was competent to possess the same for himself or to settle the same to any other Rayas. Panu Mandal, Babulal Mandal, son of Beni Mandal, Keso Mandal, Gosu Mandal, son of so and so, Bodhi Mandal, Edu Mandal, Buhi Mandal, and Jagannath Mandal, son of Chand Mandal, were settled Rayas of village Saharjori. They requested the landlord, namely Mujira Mato, to settle the land mentioned in the schedule below for converting the same into a tank for erecting agricultural lands. Mujira Mato, the landlord tenure holder of Moja Kundaha, agreed to settle the same to them, and accordingly Mujira Mato settled the land mentioned in the schedule below to the aforesaid Panu Mandal and others on 6/7/1935, again by registered deed of settlement being deed number 3048 for a valuable salami accepted from them in the said settlement. Though Asu Mandal had surrendered the land through his mother Basana Mandalain, wife of Jalal Mandal, also joined the settlers of the land mentioned in the schedule below.
That's right. Basically, there was a settlement, and the defendants, according to you, had only 1/9
Ninth
share,
share.
and you claimed to have
All this, there were
8/9
different
share.
different, all the
different
plaintiffs.
shares, but the plaintiff claimed 8/9
Right.
share.
My lord.
8/9 share.
8/9. Now what happened, my lord? If and the defendant appeared, my lord, they contested the suit. If, my lord, the precise issue that they raised that the deed of surrender was, if I just place it, my lord, I have gone through this
Yes.
one.
Yes.
Deed of surrender is an outcome of force and fabrication. This is their
The
specific.
deed of surrender way back in
1935 is an outcome. If I just place, my lord, page number, internal page 7, if my lord will come.
Yes, and there.
And further, if I place, my lord,
The so-called registered deed of settlement
yes,
is a forged and fabricated, manufactured and collusive document.
collusive document, that would say.
And the LS settlee did not come in possession of the land on the basis thereof.
Thereof. That is what they say.
This was surrendered in favor of the landlord.
Surrendered in favor of landlord, my lord.
Yes.
And landlord then settled with us by registered deed. If my lord will just come to
And the
that.
LS settlee did not come in possession of the
If
land
my
on the
lord,
basis.
just for a moment, my lord. Page
You
number.
see, there is no question of settlement by virtue of surrender deed. Settlement is a subsequent act.
Subsequent. That is what I am submitting. My lord, will kindly come to page number 3 of this judgment. Internal page. The bottom part, my lord, I was still to place that, my lord.
Yes.
I will say, my lord, that Muchi Ram Mato, the landlord tenure holder of Maja Tundaha, it will be, my lord, almost 10-12 lines down. My lord.
Yes.
My lord has got it.
Yes, I got.
Muchi Ram Mato, the landlord tenure holder of Maja Tundaha,
I've seen it.
agreed
He
to
settled.
settled in favor of Pan and others on 6/7/35 by registered deed of settlement being
Yes.
deed number so.
Yes.
So we are the descendants of that Panu Mandal, my lord, and we are the
Yes.
plaintiffs. So this is what they say, that it is a forced, collusive, and we were never put to possession.
The defendants are your full brothers.
No,
They're of the same family.
no, they are not of same family.
Then why this
The
share?
settlement, no, he also, her mother, because my lord, at that point of time, my lord, the right of inheritance was not with the ladies. She surrendered the property because his son was minor. So, and then when it was chance of settlement, they were of same village, they all made request. So, Zamindar landlord, what he did, he settled with all this by registered deed in favor of 1/9 all.
Okay.
This was the settlement. How?
All right.
So, mother was there.
Okay.
And what then happened, my lord? If based on this pleading, if my lord will just kindly come to page number 9, what is the issue for you? First four issues are my lord, simply on the points of maintained barred by principles. 5 and 6 will be relevant. Whether the suit tank was surrendered to ex-landlord by Asu Mandal in 35, and whether ex-landlord, namely Muchira Mato, settled the suit land to Panu Mandal and other in 6/7/35 and put in possession. And whether the plaintiffs and defendants are in joint possession. Now, my lord, your lordship will find from page number, then oral evidences have only been brought to some extent. Why I am placing page number 10.
What is the finding?
Page number 10, two more facts I will just address. Para 5, Exhibit 1, Deed of Patta, we had as due 6/7/35. Exhibit 1 by a certified copy of Deed of Surrender,
28 says 35, and then one order sheet of 87. Then oral evidences were reduced. Then page 11,
This case was decided in your favor.
no, I lost. It is against concurrent finding. It is
No,
against.
no. This case under section 87.
No, some of the plaintiff, 2, 3, they filed this and this was dismissed for non-prosecution. That is a fact. We talk on record. Then comes page 11, what document has been brought, that I am just placing it. Page 11, rent receipt issued by government, rent receipt so and
This is
so.
by the defendant.
Defendants. This is the document. Now oral evidences that has been discussed, I will just come to the finding part, page 14.
Yes.
That two issues that I referred, whether surrender was a.
Okay.
So if I place this,
You just come to the finding, but let us
Yes.
see what is the finding.
the finding says that finding
On the basis of
also
alleged
in view of
legal
circumstances and also in view of the fact, it can safely be said plaintiffs have no right, title and interest on the suit land on basis of the alleged oral documentary evidence. Hence, the issue is hereby decided in favor of the defendant. This is perversity because I had brought the registered document which is more than 60 years old, when 30 years old. It is a public document, certified copy of that. Those documents were produced before the Honorable Court. The finding is raised that oral evidences.
Were you paying rent?
I let rent. We have reduced that we have, but document rent receipts have been not documented. So we will have to. But my submission would be valid. My submission, it was in jointness because it is a tank. It is not disputed by other parties. It is a fishery tank. Now, what is the basis of this finding? If your ladyship allow me, the basis is that
Ashu Mandal was paying rent.
Asu Mandal was not the settlee also. Ashu
Mandal was the person who had surrendered
through his mother.
through his mother.
Minor.
Rather, Ashu Mandal has been paying rent.
That document he has brought on record. We are
Yes.
not averse because that was
And then they continued to pay rent.
minor section 87 declaration was there because entry of subsequent survey was made in his name in the revenue record. Ashu Mandal.
Did you ever object to that?
But we filed 87 that was dismissed for non-prosecution. But my submission would be valid. My submission, the payment
So,
of rent receipt.
We can understand that they were paying rent and you were also paying rent. You were not paying rent.
I was not paying rent. That is not a document brought on record. We were in joint position. We were harvesting the outcome of the. And
How do you say joint possession?
that even if
What is there
even
for
if for a
joint
moment,
possession?
even for a moment, my lord, if there is no rent receipt to that effect from my side, there is a registered deed. There is a registered deed which specific pleading is that it is forged and fabricated. There is no finding on forged and fabricated. Rather issue has also not been framed. So what is the material? An entry of revenue record, my lord, or rent receipt are only documents of possession. He has not set up a case of adverse possession. He has not set up a case of adverse possession. And the document which is before my lord, these are two registered documents.
His claim was that the
The
property was never surrendered.
surrender.
Yes.
No.
And Ashu Mandal and his descendants, they continue to be in possession of the property.
He said, but what
That was his case,
So,
and
that-
that is the finding.
no, specific pleading was there, my lord, that it is a forced, fabricated and collusive document. Neither issue is framed, nor finding is written on this. Now it is a registered document more than 30 years old, my lord.
The
Our-
finding is that there was no surrender.
That is why I am saying that is patent illegality, my lord, because to dispel a
Surrender
registered.
is coupled with giving possession.
No,
Merely because there is a deed of surrender, that is not sufficient. It has to be coupled with delivery of possession.
if I take my lord to section 91 and 92 of Evidence Act, if the document is self-speaking registered document, oral evidence cannot come forward
No,
to
there
display.
is no question of
And
evidence.
rent receipts, my lord, in a case questions of
What is the evidence of your possession
my,
apart from those
my
documents?
all witnesses, oral witnesses have come forward and said that we are in joint possession. We have said so, my lord. If my evidences has to be scrutinized, oral witnesses, because 87 entry was made in the name of Asu Mandal, and his right has already been surrendered. So who has committed this forgery? Her mother is the person who has surrendered. Minor, it is taken that he was not minor at that point of time.
You see, entry in record of rights or entry in survey, they have lot of evidentiary value. You have not taken appropriate steps under section 87 to get it rectified. You got that petition dismissed for default. And subsequently, after scrutinizing the records, it has come that it was the defendants who were in possession of the property. And what
My lord,
you
if
have-
these two issues that has been decided, based on that, the third issue is decided, my lord, the possession. The two issue that it was the surrender was bad, and what the court observes, my lord, if the finding part, if my lord will see, in view of the fact, and also in view that a forced discussion, it can safely be that plaintiff have no right, title, and interest over the suit land, no right, title, and interest on basis of the alleged oral and documentary evidence. Is my right confined only to oral and the documentary evidence is registered if my lord will have a judgment on the point? My lord, what and section 91 of Evidence Act for a moment, my lord. These are registered document, my lord. If this registered document has to be disbelieved, can oral evidence be dispelled? Because presumption is now in favor of me, and he has to come and dispel that these are the collusive document, my lord.
You see, it need not be just collusive. The point is that whether it is binding upon the respondent.
Yes, my lord, in my humble submission, because he was minor and through his mother he surrendered the property. And the person, it is not their case that surrender was made to an incompetent person. Landlord, at that point of time, the surrender could have been effectuated. And landlord thereafter surrendered. It's not that even mother is also claiming that right. So she is not plaintiff here, my lord. So, and the basis is, my lord, the most surprising and why I say it is suffering from patent illegality, that it says that record of right, name of Asu Mandal is there, mother's name is not there, my lord. Mother's name, right to property, my lord, to a late female under Hindu law before 56 was limited. They cannot be entered in the record of right unless they are self-acquired property. Based on inheritance, their name cannot be incorporated. One. Two, that Asu Mandal, it says that since his name was recorded in the record of right, so it will be presumed that he is major. My lord, record of right nowhere indicates the age. It only indicates, and minor's name can very well be entered in the record of rights, my lord. So these two propositions which the court has taken, holding that the my surrender was, and there is no issue and no finding on forged fabricated collusion. So my right, title, and interest cannot be dispelled. In my humble submission, my lord, if the findings will be seen, what is the presumption? It is a registered document, my lord. Presumption is in my favor. By cogent evidence, they have to dispel first of all this document.
What is Exhibit 1?
That is my registered settlement. That is deed of settlement, my lord, which is in our favor. And 1/A is the surrendered, my lord. Now the court says that certified copy, very peculiar, my lord, that I have not brought that paragraph. If I refer, my lord, it will be for certified copy. What is the finding given, my lord? It is against the judgment of Honorable Apex Court. Page number 18. Page number internal page 18, my lord. If my lord will just have a kind look to it. My lord, may kindly come to page number 18. If my lord will just have a
It
kind.
has been stated that it is a suspicious document.
Yes. What is the material? That is why it is said suspicious, my lord. I am just pressing page number 18. What is the underlying reason the court is finding for declaring it to be
For
suspicious?
non-production of original.
Original. So, my lord, 30 years, that is the judgment. If my lord will have a kind look to this, 2023 SEC online 1183, my lord. It says that since I cannot bring the original deed of settlement, so it is suspicious. This is 2023. If just for a moment, my lord, what is the value of a certified copy of an original? Rather, it is said that
It is
it's
more,
probably, my lord is consciously
it has
aware
got
of
more value.
more value because it is prepared from the original. So, my lord, this proposition, I am
And coming from a authority.
authority. My lord is now I need not require to submit on that aspect. My lord is consciously aware.
Rather, I remember that people are also advised that when you file the original deed, you also file a
But I
certified
have filed
deed.
in probate case. Now recently I have done so. In light of
Because
this,
that will show its authenticity and court will believe that document
I bow down, my lord.
on the face of it.
I bow down, my lord. And that is what he said that since I could not bring, so it is suspicious. Like, hey, the court has
This
gone.
is what the trial court has done.
The appellate court has done one more thing, my lord. Appellate court has departed from this finding. My lord will kindly come to page number. Page number 14. If point of determination is made, my lord.
Yes.
Just I will quickly.
Page number 10.
Page number 10. Both are taken together, my lord. Whether the property was surrendered to ex-landlord and the settled in favor of plaintiff and defendant on 6/7/35 by the ex-landlord, and whether the plaintiff and defendant are in joint possession of the on basis of registered settlement deed 6/7/35. Finding is in one paragraph. He has discussed all the more in the same line what trial court did, page 14. After going through the above discussed registered surrender deed and registered settlement deed, I find that the both deeds were not acted upon because plaintiff appellant have not brought on record any rent receipt to show that they are in possession of the suit property.
This is what there is. That is what.
No, but my lord, the deed, registered deed says that possession has been handed over. Settlements with that document.
Registered deed by itself is not an evidence of handing over.
If, my lord, if the registered document says, my
The
lord,
registered document,
if I,
recital of the registered documents are required to be proved.
I have proved that, my lord. I have proved, but what happened, my lord, we have pleaded that. 87, when his name was entered, we challenged, but we missed some of the defendant had challenged, plaintiff. And that was dismissed for non-prosecution. Then finally we went for a partition. We are deriving, my lord, if a registered document says that delivery of possession is effectuated, Exhibit 1, then my lord, the law will presume in my favor, my lord, because it is a registered document. Onus will be on other side to dispel.
They have done it?
So only based on oral evidence and
No.
some
They have-
rent receipt. My
Not
lord.
some. Rent receipts have lot of value.
My lord, I don't deny, my lord. but
Right. You have
rent
seen the
receipt-
value of the rent
Ma-
receipt in 24 judgment.
My lord,
Rent receipt is an evidence of
possession. Yes, my lord. But it cannot oust my possession, my lord.
No. you
He
see,
can, because
Two people, एक म्यान में दो तलवार रखते क्या?
my lord, that is what I say, substantial question of law. If I have formulated, my lord, 1, 2 and 4, if just, my lord, based on this fact, if your lordship considers that it is a fit, because why I am saying that rent receipt, they say that because deed was bad, so I don't have
No,
a title.
that is not the reason given
So
by the appellate
where
court.
is the issue, my lord, that it has not been acted upon? Pleading, order 14, issue. Evidence has to be laid on issue. My lord will have a kind look to the issue. What issue originally was framed? Have a look to it, my. Page number 9. If issue number 7, 8 may be seen, my lord. 7 and 8. Whether the plaintiff and defendants are in joint possession of the suit land, and whether the defendant is in joint possession of the plaintiff and not on the basis of CS Khatiyan. Whether RS Khatiyan for the suit tank has been wrongly prepared in the name of the defendant and their predecessor in interest. This was also
Issue
one
number
of
5,
yes.
whether the suit was surrendered.
Yes.
So it was not acted upon. It's the
But
part
surrender,
of this.
my lord, these are two different things. If I make my humble submission,
Whether the defendants are in joint possession with the plaintiff.
acted upon, no issue has been framed that it has never been acted upon. They in their written statement, this is not their case. The trial court has verbatim taken the written statement. Nowhere it is being said, my lord. And that issue of 87 was specifically framed, my lord, in the title suit civil court, my lord, that whether 87 is wrongly entered. And
Where is it mentioned? That whether 87 is wrong? Where is that?
issue number, your lordship, issue number 9, page number 9 itself, issue number 9. Whether RS Khatiyan for the suit tank has been wrongly prepared in the name of defendants and their predecessor in interest.
This is the point of whether it has been acted upon or not, isn't it?
The acted upon, in my humble submission, just for appreciation, my lord, because I understand that my passage is narrow, my lord, but where patent illegality or perversity or procedural lack is there, my lord, I will not invite for appreciation of evidence. Now, what it will said for that, here specific case is that it is a forged document. So whether his mother has forged it, no evidence on that. Now coming on to entire title based on this revenue receipt, my lord, which is itself a issue here, and that will be
Page 16.
From where do you say this 87 petition was dismissed for default?
yes, my lord. In my then in my plaint also there is, and by quoting my plaint where it is being said, my lord, if I just place it, if page number 4.
It must have been exhibited. Or
Yes,
the sheet
exhibit
was
3,
exhibited.
exhibit 2 is the one by and 2. I have brought before the honorable court this document, and we have pleaded also, my lord. If middle part, internal page 4, has been dismissed by order and said that Khatian has been rightly prepared, I stand back. If I just place the plaintiff filed a suit under 87, being suit number so and so in the court of Central Dhanwad, which was subsequently transferred to Sri B.B. Verma Revenue Officer due to misunderstanding of dates. The plaintiff could not take proper steps in the suit, and therefore the suit of 87 Act has been dismissed by the revenue officer by order dated, and the said R.S. Khatian has been rightly prepared in the name of the defendant. R.S. Khatian was, which was finally is not correct to the extent that defendants are not the only interested person, or they have no right, they have got no right title interest over the entire land mentioned in the schedule below. They have got only 1/9 share in the tank. R.S. Khatian has been wrongly prepared in their names for their entire tank more fully described in the schedule below on basis of the order dated 29/9/2001. The defendants
That
are
was not a case of dismissal for default.
no, but I stand corrected, my lord. It is said that we could not take a step because it was transferred to a different.
It was said means what? Where is the discussion?
Discussion is in the
See, it
here,
is
my
there.
lord. Issue number
The
7.
plaintiff filed suit under section 87, by suit number such and such in court of settlement officer Dhanbad, which was transferred to the court of B.B. Verma,
Yes,
revenue
ma'am.
officer
Page
for
number 4.
disposal.
Yes.
And the materials brought upon record by parties, the revenue officer dismissed the suit of
Yes.
the plaintiff under
Yes.
section 87.
Thereafter, my pleading, my lord. Pleading
Yes.
part is there, my lord. So the specific issue was framed on this issue, my lord. A specific issue was framed. So
Where is
if,
the finding with regard to that
if I
issue?
take, my lord, issue number 9 is pertaining
Issue
to
number
that.
9.
And it will start, it starts from page 16, my lord, and finding would be page 19, my lord, that last paragraph. So far these issues are concerned, having regard to the facts and circumstances of this case, and also having regard to the oral and documentary evidence available on record, and also having regard to the admitted facts of the case, and also in view of the finding of on issue number 7, 8 and 9, it is said that the plaintiffs and defendants are not in joint possession of the suit tank, hence this issue is decided accordingly. And 7, 8, 9 are
No,
taken.
you see there is a specific finding pattern, page number 16,
16.
that this order is binding on you and you did not file any appeal against this. The
So,
R.S. Khartiyan
entry-
published.
Entry in the revenue record, my lord, is not a conclusive proof of title, my lord. We are before the civil court, my lord. And a specific issue is
Entry in the revenue record is certainly a proof of
possession. Possession. I do not deny.
So possession of their possession was duly declared.
The possession was declared, my lord, based on the fact that what is their case, my lord. If I just make a small summation, entry was of a subsequent time. It is not their case that surrender and settlement was not acted upon. It is their case that surrender and settlement is a forced piece of document. That is their case, my lord, and that registered document says, my lord, just for a moment, if my lord will have a kind look to section 91 of the Evidence Act, if just for a moment, section 91 and 92 of the Evidence Act, if your lordship will have just a kind look to that, whether this oral evidence can dispel this, And only to the extent that if anybody is claiming possession valid, it is not a case of adverse possession. He may have hundreds years of independent possession valid for himself, but he cannot dispel the right of other owners unless he sets up a case of adverse possession. In my humble submission, the proposition of law is very clear, man. A person sitting on the right of others, possessing the property, even for 100 years, unless he comes up a case of adverse possession, he cannot extinguish the right of the actual owner. And nowhere it is pleaded that I am, by virtue of adverse possession, I am in possession of the property.
The plaintiff sought a decree of confirmation of joint possession of plaintiff and defendant to the extent of 8 by 9 share.
Yes.
So once they are claiming joint possession, it means that they are admitting the possession of the defendant as well as
Yes,
their
yes,
possession.
we are admitting. Our case is very specific. Based on that registered document, if I just clarify my, just for a moment, it is not their case, my lord, that they have acquired the title by virtue of adverse possession.
That's
It is their case that Asu Mandal was the original rajah. He never surrendered the property. The document is collusive, forced. Therefore, the right cannot be parted away, and the Asu Mandal's right cannot be extinguished, and right cannot be created in favor of so and so. The court gives a finding that these two documents appears to be suspicious, based on the fact that I failed to produce the original document. Now, the court therefore says that, and court takes into consideration that 87 proceeding is in their favor. 87 proceeding once is in their favor, therefore their possession will be recognized under law. I take it for a moment that even if their possession is recognized under law, whether my right over the property will be extinguished unless they set up a case of adverse possession against me. This is my whole sole submission. If his possession is there, my lord, am I clear, my lord, on this point? If his possession is confirmed, whether my right over the property will be extinguished based on that registered deed of settlement, when the fact remains that there is no finding on the forgery and the registered document remains intact, when the fact remains that the appellate court has taken something beyond pleading, that it was never acted upon. This fact, from where is the pleading, my lord? Even if any evidence is brought beyond pleading, my lord, it cannot be looked into. This is also one of the settled proposition of law, my lord. Evidence beyond pleading cannot be looked into, because I cannot be taken by surprise. Issues are framed. There would have been a specific issue whether the registered deed of settlement was ever acted upon. So, my lord, 1, 2, and 4, if my lord, this is, my lord, second, this is the last quote for me technically. So, and it can be decided, my lord, at the earliest, calling for LCR and looking into those evidence. Because 91 and 92 says, my lord, that oral evidence cannot be looked into beyond the registered content to dispel the registered content.
registered document is conclusive proof.
No, presumption.
So
So the reversal will be their duty. Now 87 they have proved their possession.
they have said that they are
Their possession. I take it as my lord that their possession is established.
So,
Whether this will extinguish my right, because they have not come up with a case of adverse possession, and their case is not that it has not been acted upon. These are the two small submissions, my lord. If my lord will consider this aspect of the matter, because I am not inviting the honorable court to appreciate the evidence.
they had taken a plea that there has been no surrender of land.
Yes. So this plea violate, there was no surrender of right. It is a pleading which is challenging my deed of settlement and deed of surrender. Now these two deeds have been, the finding has been returned that it is suspicious for want of original. So my submission
No,
is,
no, that was by the learned trial court. The
appellate-
learned appellate court has
appellate
not
says
said-
it is not acted upon.
Yes.
So it is not suspicious. My lord, there is a gulf of difference, my lord, between suspicious forgery and not acting upon. It is not their pleading, my lord, that it has not been acted upon. So any finding of the court beyond pleading, my lord, in my humble submission, will not be taken into consideration, my lord. The court, where is the pleading of the written statement? The trial court has quoted it. The trial court nowhere says that it has not been acted. It says it is a forged piece of document. And there is no finding on forgery. And appellate court also says it is a valid piece of document when it says that it is not acted upon, means that the document was in existence but it has not been acted upon. So where is that pleading? I am putting a question to myself.
Heard the learned counsel for the appellant. The learned counsel for the appellant has submitted that although both the courts have dismissed the suit filed by the plaintiff, but the trial court took a view that the certified copy of Exhibit 1 and 1 by A was suspicious document as the original was never produced. But the learned appellate court has given a different reason for dismissal of the appeal by holding that the document was that the surrender deed was never acted upon. The learned counsel submits that though both the courts have recorded finding that the defendants were in possession of the suit property, but the same would not invalidate the deed of surrender and subsequent settlement.
And extinguish the right
Exhibit
also.
A, Exhibit 1 and 1 by A, and extinguish the title of the plaintiff. यही है आपका केस?
Yeah.
लिमिटेशन डिसाइड किया,
Limitation,
इशू फ्रेम किया,
issue frame. Page number 11, just one. That is issue number 3, para 12. Issue number 4. Para 12 is. Page number, last page, internal page 19. Nothing has been discussed.
The learned counsel has also submitted that so far as issue number 1, 2, 3, 4, 9 and 11,
10 and 11.
10 and 11 are concerned, the learned trial court has dealt it in paragraph 12 in one paragraph, in one short paragraph, and has simply observed that in view of specific evidence of PWs, DWs, the plaintiffs had no valid cause to bring the suit and the suit was barred by limitation, and has held that the suit in the present form was not maintainable. And so far as the appellate court is concerned, the appellate court did not frame any issue on the point of limitation and has dismissed the appeal. He has submitted that the aforesaid point of limitation / cause of action certainly fell for consideration and was also required to be decided by the appellate court,
Grateful.
which has not been done in the present case. And therefore, the provisions of Order 41/31 has not been followed under the facts and circumstances of this case by the appellate court. Considering the submissions, this second appeal is admitted to be heard on following substantial question of law. Whether the
What, page number 19, my lord of my petition. 1, 2, and 5 would be
whether the learned appellate court, first appellate court, whether the judgment of confirmation by the learned first appellate court is fit to be interfered for having not followed the provisions of Order 41/31 in true letter and spirit. B. Whether the finding of the learned trial court, whether the exhibit 1 and 1 by A and also the exhibit B, exhibit 1 and 1 by B and exhibit 2 produced by the whether the learned appellate learned courts are justified, have properly कौन सा आपका क्वेश्चन ऑफ लॉ है?
question number 1, 5, if may say, my lord. Page number 20, that this exceeding.
Whether the rent receipt which has been relied upon by both the courts could be said to be the conclusive proof on the point of title and possession of the defendant.
And this next page, my lord, 5 will be relevant. It's exceeding the jurisdiction.
Whether the finding of the learned first appellate court that the registered deed was not acted upon is based on any material on record. ऊपर लिख लीजिएगा, the learned counsel submits that the finding of the learned appellate court that the surrender deed of registered deed of surrender and settlement was not acted upon is not based on any material on record. ठीक है?
Grateful.
Issue notice to the respondent numbers.
There are two, it will be matter from 1 to 9. Page number 4.
Respondent number 1 to 9 through orderly process as well as registered cover for which requisites be filed by the appellant by Monday. Call for the records from the concerned court. Pose this case on 20th March 2025.
My lord's judgment has recently been affirmed by the Honorable Apex Court Durga Devi. I will give the copy.
Which one?
One very first judgment we argued late hour in the evening. In your initial days of justice. So this was
कौन सा?
notices Durga Devi. I will be.
क्या मैटर था?
नहीं, it was that in specific performance of contract case that that failed there. I was for appellant and it was decided. My lord holding that for vagueness the contract was failed and all aspects was dealt with.
दे दीजिएगा अभी परसों डिसाइड किएगा.
In a very initial days, I will say in 2018 itself it was decided.
I'm very fond of pure civil law.
That I find from my lord's also we will be careful in formulating that question.
वो तो आप लोग फॉर्मुलेट ठीक से नहीं करते.
No, we will be careful. Cases are coming after 6-7 years, so our experience also are moving. Great.
2-3 जजमेंट्स हैं. द सेटल प्रोपोजिशन ऑफ लॉ है सेकंड अपील का फॉर्मुलेशन ऑफ सब्सटेंशियल क्वेश्चन ऑफ लॉ पर उसको ध्यान में रखते हुए
Yes.
फॉर्मुलेशन करना चाहिए.
2012 Supreme Court elaborate.
हाँ, अभी रीसेंट भी है.
Recently, yes.
रीसेंट भी है. बोलेंगे तो आप लोग सबको दे देंगे. हम तो 3 कॉपी करा के रखे. एक
नहीं.
कॉपी वहीं रख दीजिए.
हाँ.
एक कॉपी 3 कॉपी है ना. 3 सेट कराए थे हम लोग इसका.
Citation मिल जाएगा.
एक सेट देखिए आप लोग के लिए. लीजिए वहाँ रख दीजिए. लीजिए कोर्ट्स कॉपी बोल के बट लेके नहीं जाने का है.
Citation करेंगे.
नहीं आप रख लिया वहीं रखे रहिए.
हाँ.
क्योंकि हर एक को चाहिए ना लोग.
Yes,
नहीं
I will just-
पता होता. चलिए नेक्स्ट.
Great.
Item
2-3 जजमेंट्स हैं उसमें.
second till 167 of 2020.
ये सप्लीमेंट.
The suit for declaration of title and recovery of possession in which I was the defendant. There is a concurrent finding of fact, a concurrent finding by both the court below in favor of the plaintiff. I am the defendant. The case of the plaintiff was that Kedar Rao, the recorded tenant, had a plot number 3387 in which consists of about 13 decimals.
जस्ट मोमेंट. उसमें रिकॉर्ड कॉल फॉर करना है. फैक्स करना है. हाँ प्लीज करिए. थोड़ा सा सॉरी थोड़ा सा माइंड डाइवर्ट हो गया. बताइए क्या केस था प्लेंटिफ का.
प्लेंटिफ का केस था कि the plot number 3387 which consists of 13 decimal out of which 6.5 decimal land has been sold to the defendant, to the appellant, meaning thereby to the appellant in the year 1981 by registered deed. And but he in the northern side of the plot, but he taken possession over the southern portion of the plot. So the suit was filed in the year 2004 for declaration of their right, title and interest, and also for recovery of
With respect to which portion of the land?
southern portion.
Southern portion.
Southern
The
portion.
which portion of the land was sold? Northern portion.
Northern portion.
By registered deed.
Wider registered.
All right.
All right. We
So
lots of
saying it just a moment. Sale deed was with northern portion and suit for recovery was
for southern portion.
for which no sale deed was executed.
No sale deed was paid, it is an admitted position, but my written statement was that yes, I had purchased northern side of the plot number 3387, 6.5 decimal, but after sale deed, when measurement was done in presence of the vendor and other person of the locality, it was found that about 6 decimal of the land has already been acquired by the government for construction of the road in the year 1963 itself. So I complained before the vendor, they agreed that you take the remaining part of the land.
This
And
happened when?
in the year 1981, that is the finding of the trial court itself, that I am in possession of the southern part of the.
Did you claim adverse possession?
Yes, but that has not been decided.
Did you claim adverse possession?
Yes,
Where is it?
that was my specific
Where is it?
pleading.
Where is it that
Yes,
you
Your Lordship.
claimed adverse possession? Your written statement.
In my written statement, Your Lordship, it had come in the judgment also, page number 12, 11, internal page number
On the
11,
trial court judgment first.
trial court judgment.
आपका अपना written statement बताइए.
हाँ, written 46 रनिंग पेज में लिखा हुआ है. Independent in assertion of the own right thereof within the knowledge of the person of the locality in general and father of the plaintiff number 1 to 4, and thereafter the plaintiff in particular for more than the statutory period of 12 years have perfected their title by adverse possession. So they have taken, trial court has recorded my written statement in this judgment, Your Lordship, and the finding. So no issue on that point has been issued, but my submission was that since I am in possession of the land since 1981, so suit is barred by limitation because it was filed in the year 2004, so it was barred by limitation. Now what the trial court has given its finding, Your Lordship. If Your Lordship will see page 17, internal page 17, running page 52, I further found that there is no any cogent evidence with regard to government acquisition. So one point they have taken, although I have filed exhibit C, which was the notice of acquisition, which was not taken into consideration. Neither plaintiff nor defendant proved any document regarding land acquisition of the said plot. Therefore, it cannot be said that PWD Department of Government acquired about 6 decimal of the land of the plot number 3587 लिख दिया 3387 जो भी होगा for construction of चंदन क्यारी धनबाद रोड
नहीं ऐसे नहीं थोड़ा सा इसको ट्रायल कोर्ट में तो it has been recorded but no relief was no issue was framed on account of adverse
position. Yes.
How is issue number 4 decided?
How issue number 4 has been decided simply that it is not barred by limitation, only by giving one line. Para 8 page 17 जो हम पढ़ रहे हैं जो उसी में है, ये फाइंडिंग देते हैं कि एग्जिबिट 7 जो प्लीडर कमिश्नर का रिपोर्ट है उससे ये पता चलता है कि उनके साउदर्न पोर्शन पर उनका कंस्ट्रक्शन मकान दुकान बना हुआ है उन फ्रॉम द डेट ऑफ परचेज 11/7/1981 से ही, लेकिन फाइंडिंग दे दिए हैं कि नहीं आप इनका ये प्लेंटिफ का, सो वही हम पढ़ना चाह रहे हैं. कंस्ट्रक्शन के द्वारा हेंस issue number 6 is decided in favor of it is proved by the evidence of parties that after purchasing the land defendant number Gauri Rawat came in possession of the suit property. Suit property is southern part. Therefore, it is true that defendants are in possession of the suit land since the time of their purchase, that is 11/7/81. Hence, issue number 6 is decided in favor of the plaintiff. This is wholly perverse judgment. The plaintiff have sold only 6.5 decimal land out of 13 decimals. The rest land is belong to plaintiff, and they are rightful owner of the. All right. I have purchased 6.5 decimal northern side. Southern side I was allowed, and it was in my possession, hostile to the real owner. The rest land belong to the defendant also admitted that they have purchased only 6.5 decimal of the land out of 13 decimals of land. It is also even from the sale deed exhibit B that Kedar Rawat has also given 7 link land to the defendant at the time of selling land. Sale deed shows that the sold property is situated in northern side of the said plot, so defendant are rightful owner of the said plot in northern side, and the plaintiff are rightful owner of the said plot in southern side. Therefore, plaintiff have got the position over this suit land in southern side, hence issue 8 is decided in favor of the plaintiff. My simple case is, Your Lordship, that on account of the position or anyway the northern side land was not in existence, so the vendor has allowed me to take possession of the southern side, and I am in position that since the date of purchase, which is the report of the pleader commissioner also. So on that plea, this suit is hopelessly barred by limitation, which fact has not been decided, which issue has not been decided properly by the landowner. Although he has came to the conclusion that I am in possession of the southern part since 1981. Now the appellate court, Your Lordship will see,
The possession has also been decided in favor of the plaintiff.
in Exhibit 7, which is the
The possession has also been decided in favor of the plaintiff.
No, Your Lordship,
Yes.
kindly
The
have a
suit decreed on contest without cost and declared the title of the plaintiff over the property described in Schedule 2 and confirmed the possession thereof.
yes.
There was a suit for confirmation of possession and the possession has been declared in favor of the plaintiff.
Prayer of the plaintiff was for recovery of possession, not confirmation of possession. So the judge
Recovery of possession if not found in possession.
no,
Normally that is the kind of relief. This is
Yes.
how the relief is claimed.
yes, that is important.
No, for a permanent injunction that restraining the defendants from interfering with the possession of the property over Schedule 2.
नहीं उसके पहला वाला
उसके पहले क्या?
ये declaration of title of the plaintiff over the property
And confirmation of possession.
and नहीं possession thereof with the proper described in Schedule 2 is a part of the recovery of possession.
And for recovery
And
of
for
possession
recovery of possession of
described
the
in
property
Schedule 3.
3 by removing the principal dependent thereof.
Okay, ये डिग्री कहाँ किया है कि removal of possession? ये तो डिग्री कहाँ किया
Degree
है?
नहीं है, that is the perversity of the
नहीं that is not. That relief has not been granted.
that
Schedule 2 का ही possession confirm किया है.
किया है.
बात खत्म?
और-
फिर आपको क्या परेशानी?
परेशानी ये है मतलब
Schedule 3 का recovery of possession का डिग्री उनको grant नहीं किया है.
हाँ,
सिर्फ Schedule 2 का
the
डिग्री दिया है और confirmation of possession है.
yes but my
Schedule 2 जो है
हाँ शेड्यूल 2 है वो
northern portion है कि southern portion?
नहीं शेड्यूल 2 दूसरा चीज है.
क्या है?
शेड्यूल 2 है नॉर्दर्न और साउदर्न पोर्शन. शेड्यूल 3 जिसमें इसकी मांग रहे हैं रिस्ट्रेनिंग, वो शेड्यूल 3 दूसरा है. शेड्यूल 2 है लिखा हुआ जजमेंट में रिकवर्ड इन सीएस नंबर इतना साउदर्न हाफ मेजरिंग 6.5 acre including 8 links from east to west and 4 cubics from north to south on the southeastern extremely bounded by so.
देखिए जिस प्रॉपर्टी का इनको टाइटल दिया है उसी प्रॉपर्टी का उनको पोजेशन भी डिक्लेयर किया है.
Yeah, that has wrongly been decided. My submission is because the pleader commissioner report was that I am in the possession that has been found by the trial court itself. पेज 16 से शुरू करते हैं देखा जाए पेज 16 से पूरा जजमेंट पढ़ देते हैं अब इंटरनल बेसिस उसमें आया है कि हम पोजीशन में हैं. तो अगर हम पोजीशन में है काशी से तो सूट बार्ड बाय लिमिटेशन हो जा रहा है. यही हम कहना चाहते हैं. आई हैव गॉन थ्रू आई एम रीडिंग फ्रॉम आई हैव गॉन थ्रू
एक सेकंड
I have gone through the entire evidence as well as
जस्ट एक सेकंड रुक जाइए. बताइए कहाँ से पढ़ रहे हैं?
Yes, your lordship. Page 16, internal page 16, running page 51. I have gone through the entire evidence as well as documents. It is evident, even from the evidence of witnesses, that land in question is recorded in the name of Kedar. Correct? This fact has been admitted by the both parties. It is further admitted that Kedar Rawat has sold his property to the name of dependent number 1, Gauri Rawat, on 11/7/1980. It is 81 actually. By virtue of sale deed, the land in question as well as sold property is situated in Mauja Lagla, bearing cadastral survey khata number 18, CS plot number 3387. Kedar Rao has sold 6.5 decimal land out of 13 decimal at the northern side of the said plot. These facts proved by the registered deed at Exhibit 2 and Exhibit B. The remaining land of the Kedar Rao was in possession after sold the aforesaid property. Kedar Rao has not sold entire area of the property to the dependent. He is only sold his land in the northern side of the said plot. Therefore, Kedar Rawat has not left entire area of plot number 3387 in favor of dependent after sale of 6.5 decimals of land of the plot in favor of dependent white dated 11/7/81. Panchayati was held, but parties have not filed any sheet of paper regarding the same. SKPC, meaning thereby survey knowing Leader Commissioner report Exhibit 7 shows that in the northern side of plot number 3387 no construction is exists, whereas he purchased northern side. He wrongly constructed room in the southern side. So report is that I have constructed room in the northern side. Issue number 5 is decided in favor of the plaintiff without making any discussion over it. Now, second case, Your Lordship. I further found that there is no any cogent evidence with regard to government acquisition. Neither plaintiff nor defendant proved any document regarding land acquisition. That I have filed one document, Exhibit C, which has not been considered. Anyway, therefore, it cannot be said that PWD department of the government acquired about 6 decimal of land of the plot number 3587 for construction of Chandan Kyari Dhanbad Road prior to sale made by the Kedar Rawat in favor of defendant. Hence, issue number 6 is decided in favor of plaintiff. It is proved by the evidence of parties that after purchasing the land, defendant number Gauri Rawat came in possession of the suit property, that is Schedule B. I am came in possession. Therefore, it is true that dependent are in possession of the suit land since the time of their purchase. I am in possession. Hence, issue number 6 is decided in favor of the plaintiff. This is wholly a perverse
You
judgment.
see, you are in possession. They say that you are in possession of the northern portion of the property which you had purchased by virtue of the sale deed. This is in connection with the sale deed. Sale deed was in connection with northern portion of the property, and the northern portion of the property you are in possession. There is no problem about it.
No. May I correct your lordship? The suit was for with respect to Schedule 2 property.
We are not concerned. The finding here is
finding
that
to-
you have purchased this property and you are in possession of that property.
हाँ,
This is the finding.
ये तो एडमिट है, एडमिटेड बात है कि हम
Yeah.
नॉर्दर्न साइड खरीदे,
और नॉर्दर्न साइड पोजीशन में
साइड
नहीं
में
है.
पोजीशन नहीं है, ये
नहीं
leader
है,
के-
कहाँ से बोल रहे हैं? ये तो फाइंडिंग यही है कि नॉर्दर्न साइड के में आपका पोजीशन भी है.
हाँ वही तो लीडर कमिश्नर को नोटिस दिया कि नॉर्दर्न साइड में प्लॉट नंबर इतना में कोई कंस्ट्रक्शन नहीं है.
नहीं है कंस्ट्रक्शन, लेकिन
हाँ,
पोजीशन
whereas-
आपका है.
ही परचेज नॉर्दर्न साइड, ही रॉन्गली कंस्ट्रक्टेड रूम इन साउदर्न साइड.
दैट्स राइट.
हमने साउदर्न साइड में रूम बनाया. साउदर्न साइड में उसी समय से ये फाइंडिंग आ गया कि 11/7/81 से हम साउदर्न साइड में हमारा पोजीशन है. ये फाइंडिंग आ गया बाय द लंडन ट्रायल कोर्ट इटसेल्फ. तो हमारा पोजीशन अगर 1981 से साउदर्न साइड में है, वट एवर में बी द रीजन आइदर एक्विजिशन और नॉट एक्विजिशन, इट वाज my possession
So
since
defendants are the rightful owner of the property on the northern side.
Yes.
The plaintiffs are the rightful owner of the property in the southern side.
Right, that was a wrong finding. That was a finding is correct. But my submission is, when a finding of fact has came that I am in possession of the southern side of the property, the suit is barred by limitation. Because I am in possession since 1981. So, and the suit has been filed in the year 2004. Whatever be the reason, I am the rightful owner of northern side, and for whatever be the reason, either acquisition or anything, I was allowed by the vendor to construct house in the southern part, and I have constructed house for which the original vendor Kedar Raut had not made any objection. And thereafter, after his death, his heirs have made filed the suit for recovery of possession of the southern part after more than 12 years. So the suit was hopelessly barred by limitation. So that issue has to be decided in the right perspective by the learned trial court, which has not been decided. That is one substantial question I am raising, your lordship. And second thing, so issue of limitation has not been properly decided by the. I am simply saying ठीक है उनका है, लेकिन मेरा पोजीशन में काफी से है, तो आपको 12 साल के अंदर सूट फाइल करना चाहिए था.
तो आपका पोजीशन नॉर्थ साइड में भी हो गया, आपका पोजीशन साउथ साइड
में भी हो गया. हाँ,
दोनों आप रखेंगे.
दोनों हम रखेंगे, चाहे जो भी कारण हो. नॉर्थ में एक्विजिशन हम कह रहे हैं कि एक्विजिशन
नॉर्थ में तो आपका पोजीशन डिक्लेयर कर दिया, आपका टाइटल भी डिक्लेयर कर दिया.
हाँ, वो है, लेकिन उसमें वहाँ पर कोई जमीन है नहीं. नॉर्थ में जमीन है नहीं, वो रोड बन चुका है ऑलरेडी. उसमें से 5.5 डिसमिल सरकार ने ले लिया, और चूंकि बहुत पहले लिया था इसलिए कोई डॉक्यूमेंट नहीं प्रोड्यूस किया जा सका. ओनली एक्सेप्ट वन डॉक्यूमेंट, एग्जिबिट सी. सो जो कि प्रूफ करता है कि उस एरिया में वहाँ पर लैंड एक्विजिशन हुआ था. अदर डॉक्यूमेंट आई कुड नॉट प्रोड्यूस, द पार्टीज कुड नॉट प्रोड्यूस, बट the fact remains that the northern portion of the land was not in existence at the time when the suit was filed. When I purchased the land.
That you have purchased the northern portion of the land and you are in possession of the property. ये finding गलत है?
Finding गलत है ये
कहाँ से? ये तो आपका ही कहना है.
नहीं, मेरा कहना है, मेरा रिटन स्टेटमेंट में देखा जाए, मेरा कहना है कि परचेज जब हम किए उसके बाद नापी कराने गए तो हमको नॉर्दर्न साइड में कोई प्लॉट नहीं मिला.
परचेज करने के बाद नापी कराने गए?
हाँ, उसके बाद
लोग नापी पहले कराते हैं तब परचेज करते हैं कि परचेज कराने के बाद खोजने जाते हैं कि कहाँ है लैंड? ये कोई मानने वाली बात है?
इन प्रेजेंस ऑफ द वेंडर कराए हैं एंड अदर रिस्पेक्टेबल पर्सन ऑफ द लोकेलिटी, वो नाम भी दिया हुआ है उसमें. तो वहाँ पर नहीं था. देन वेंडर अलाउड मी टू मेक कंस्ट्रक्शन इन द साउदर्न पार्ट. So when I was given possession in the year 1981, suit for recovery for possession after more than 12 years is barred by limitation. That is my first substantial question. Now, appellate court's order, if your lordship may see, that is not in accordance with order 41, rule 31 in its two letter in spirit. However, he made a point for determination in page 17, para 13, your lordship will see, running page 28. Point number 1, whether the impugned judgment and decree passed and prepared by the court below has any infirmity and the same are liable to be set aside. So it is not a definite point definite point has not been formulated for determination by the learned appellate court. And if your lordship will go through the next page, page 18, the case of the appellant defendant is that. No, I am skipping that. Page 20 में आते हैं. running page 31, when the last paragraph, when the factum of acquisition of land by the PW does not stand proved, then the question of Kedar Rao relinquishing his right, title, interest and possession over the suit land in favor of the appellant defendant does not arise at all. Moreover, besides DW5, no other witness has corroborated the factum of the alleged measurement of land of plot number 3387 after its purchase by the appellant defendants and relinquishment of the right, title, interest, possession over the plot number 3387 by Kedar Rao. As far as possession over the suit land is concerned, the defendant have not mentioned in the pleading as to whether after purchasing the land they got mutated their name or not, or if yes, then what was the Jamabandi number. They have simply filed two rent receipt. Rent receipt filed किए हैं, but the law is well settled that the rent receipt cannot be considered to be the proof of possession. Both things they himself say. As far as oral evidence on the point of possession is concerned, witness examined by the parties have quite naturally supported the case of the respective party. This is wholly uncalled for, your lordship, because they have to consider the oral submission as well as documentary submission. Otherwise, also since the alleged relinquishment of the right, title, interest and possession over the suit land by Kedar as claimed by the appellant defendant stands disproved, the natural corollary would be that the possession over the suit land would remain with the respondent plaintiff. As far as the report of the survey knowing pleader commissioner showing possession of the appellant defendant over the suit land is concerned, in the case of so and so, it was held that the pleader commissioner is not supposed to collect evidence and determine as
You
to.
see, your specific case was that northern portion was acquired and therefore in exchange you gave up the possession of northern side and you shifted to the southern.
Southern side.
But the courts have declared your title and possession with respect to northern side also.
Northern side also.
That was not your case.
Not my case. That was not my case. I have shifted with the permission of the vendor to the southern side, constructed shop and houses also, and remain in possession since 1981. So the judgment finding of the appellate court is also not because the landed, the survey knowing pleader commissioner has simply reported about the factual as physical status of the plot in question, the land in question, the suit land. So the judgment, by relying upon the judgment and saying that the survey knowing pleader commissioner has no right to decide the possession, it is not relevant for this purpose. So he only reported about the physical status of the suit land, that the defendant are in possession of the southern portion. नॉर्दर्न पोर्शन में कोई जमीन नहीं है, वहाँ पर
नॉर्दर्न पोर्शन का आप राइट
रिलीफ नहीं मांगे थे, हमने रिलीफ नहीं मांगा था, हमने कहा था कि ये हम नॉर्दर्न पोर्शन के जब नापे तो मालूम चला कि नहीं है, एक्वायर हो चुका है, तो हमको साउदर्न वाला दे दीजिए। उन्होंने एग्री कर गया, साउदर्न वाला दे दिया, उसमें हम मकान बना लिए और उस समय से हम पोजीशन में है, ये फाइंडिंग ऑफ फैक्ट आ भी गया।
तो आपको नॉर्दर्न से कोई लेना देना नहीं,
कोई लेना देना
ये
नहीं।
जो फाइंडिंग किया है, ये जो फाइंडिंग दिया है कि नॉर्दर्न भी आपका है,
हाँ,
तो यू आर रेडी टू रिलिंक्विश इट।
यस यस एब्सोल्युटली। Because of the fact the physical status of the land is concerned, 6.5 डिसमिल में से 5.5 डिसमिल ऑलरेडी रोड में बन गया, रोड में चला गया, 1 डिसमिल उसमें खाली बचता है, इसलिए नॉर्दर्न पर्सन से हमको। उसके बाद पैसेज अलॉन्ग विद द रजिस्टर्ड डीड में पैसेज भी था, पैसेज जो 3 में लिखा हुआ है।
तो अगर नॉर्दर्न पोर्शन का कोई भी जमीन इनके पास गया होगा तो उनको तो कॉम्पनसेशन मिला होगा ना उसका।
हाँ, ये सब एविडेंस में नहीं आया है, ना ही कोई ये आया है। एक तो नोटिस केवल हम लोग डाले हैं एग्जीबिट सी, जो कि कंसीडर नहीं किया गया, लेकिन फैक्ट यही है कि वो एक्विजिशन बहुत पहले हमने परचेज करने के बहुत 20-25 साल पहले 1963-64 में एक्वायर हुआ था।
आप एफिडेविट फाइल कर सकते हैं कि आपको नॉर्मल पोर्शन से कोई लेना देना नहीं है, इन कनेक्शन विद विच राइट टाइटल इंटरेस्ट एंड पोजीशन हैज बीन डिक्लेयर्ड इन योर फेवर।
यस यस।
फाइल करिए एफिडेविट, उसके बाद ही नोटिस करेंगे। दोनों तो आपको नहीं दे सकते ना।
हाँ नहीं, एकदम हम उसको छोड़ने के लिए तैयार हैं, हम
हाँ, तो
उसको बाय
affidavit
राइटिंग
file-
दे सकते हैं।
एफिडेविट फाइल करिए।
हाँ ठीक
कब तक करिएगा? उसके बाद ही एडमिट करेंगे, ऐसे हम करेंगे ही नहीं है।
ठीक ठीक है, जो हम इंस्ट्रक्शन भी ले लेते हैं, आप 2 सप्ताह के अंदर हम फाइल कर देते हैं। चूंकि क्लाइंट है ओल्ड पर्सन, एक तो चीज है गौरी
सेकंड हाफ में लिखाएंगे,
गौरी परा रात तो
देखते
एक्सपायर
हैं
कर
सेकंड
गया।
हाफ में लिखाएंगे।
हम तब तक इंस्ट्रक्शन भी ले लेते हैं।
हाँ ले लीजिए।
My lord.